Option B, item 2. What to like? Item 2.
Item number 1, delivery order.
দেখুৱাই দিয়কচোন ক'ত লিখি থৈছিলে we give a little preference to the criminal matters before we take up the
Okay.
delivery of orders, otherwise everybody keeps waiting. At 2. Yes, at 2.
May please, Your Lordship, kindly allow passover for time being.
Item 3.
May I please, Your Lordship? In this case, if it is calculated from the date of order, today 60 days, and if the excluding the date of arrest, my lord, then it would be 59 days today. The quantity involved is intermediate. So far as the
take instruction.
At 2.
After some time, I would take
After some
inspection. To take inspection regarding.
Are they filing it today or not? That is the only issue. Huh?
I am.
After some time.
21 B, Lordship.
Sure.
Reference is 7, Lordship.
We'll call for the CD.
Just above a small quantity, Lordship, 6 grams, Lordship.
What? We'll call for the CD.
Yes.
Call for the CD list again on
11th of March.
11th. 11th. Let the CD come.
Then 5.
Notice the respondent number 2 as per the usual, as per the prevalent notification. Call for the CD list again on 16 or 17.
This is
Huh?
17.
16.
Charge sheeted matter, my lord.
Charge sheeted. Scan copy of TCR. CD no hai, huh? Call for the scan copy of TCR. Notice to the respondent number 2. List again on 16th of March.
Item 6.
May I please, Lord. My lord, 26 days in custody, Lordship.
256 days.
26 days, Lordship.
226 days.
So the allegation under 20 B, Lordship, intermediate
Intermediate
quantity.
quantity.
Just above the small quantity, Lordship, 1.598 kg. Just above the small quantity, Lordship, 26 days in custody. Lordship, regards of 37 law, it not come, Lordship, may kindly consider.
CD along with FSL got 12.
CD na? CD and
CD.
official report.
Lordship,
The other one we have kept on?
Yes.
When?
We have kept 11th.
Lordship, which is
11th.
forward, next week, any date kindly, Lordship.
11th. Next week, see, second, now will be, why do we fix dates like this? Let us tell you. Second, after 2, the court would not be sitting. 3rd and 4th are holidays. 5th and 6th are full. 7th, we are not here. 9th and 10th, we are asking you for 11th. Can we bring it closer?
Already six-
We are advised not to sit for the day. We are sitting.
6 days.
Every day is calculated, sir. Every day is calculated. 11th of March.
May please, Your Lordship. May please,
Huh?
Your Lordship, 483 application, Lordship, petitioner were arrested on 2/2/2026. It's
2
from
to
Solicitor,
26.
yes, my lord. Allegation against that some cows, they are carrying, petition number 2, carrying the vehicle, my lord, but they have the certificate from the Gauhati, Lordship, that were not stolen, only the police intercepted.
Huh?
The police intercepted them.
Who is one? Petitioner one is one. Who?
Petitioner one is Lordship, driver of a vehicle,
Ah,
and the Rafiqul Hussain is one of the purchaser of the cattle, Lordship. With the documents, my lord. I have annexed the.
yes, why when the documents are there?
This document certificate provided by the Gambura man. From where it was purchased, Lordship.
When intercepted, they have provided the.
Yes, we have provided, but they have not accepted, Lordship. These are the certificate, Lordship, provided by the Gambura from whom it was purchased, and by whom it was purchased, that is also mentioned in the certificate, Lordship. Certificate I have an lordship.
When we were arrested, 2nd of February.
2nd of February also.
How soon whether this cow is the same cow? Gauhati statement is all that you need.
That's,
Whether it is the same cow or not, he has given a certificate. He must have seen the cattle,
yes.
is it not?
But his name is mentioned in the certificate, my lord. Who has
Not
purchased
true.
from whom?
There can be 1 certificate and 5 cattle roaming around. 1 certificate against 5 cattle, is it
No,
not?
no, no.
That is why we want to see the statement of the Gauhati that this is the this is the cow which was sold in front of the cat.
9th.
Huh? 9th.
As per
9th. The call for the CD 9th of March. The APP has shall have specific instruction as to whether the cattle which is certified to be sold is the cattle which has been recovered. That only one that.
June 9.
Hmm. Ah.
Lordship, in this case, Lordship, the petitioner was arrested on 13/11/2025, and as on today, Lordship, 107 days. And he, along with another accused, arrested, Lordship, and the co-accused approached before this honorable court, Lordship, which is on page 24, Lordship. Lordship was pleased to grant bail, Lordship, on the ground of, Lordship, non-compliance.
47 and 48.
Lordship, 36, 47, and 48.
What about you?
Lordship, my case, I have annexed the, all the, Lordship, Lordship, 36 notice will find page 21, Lordship. There is no signature of the witnesses. Page 21, Lordship. And
What about the 48?
48, Lordship, not served to us, Lordship.
Today is the 27th. We'll have it on the 2nd. Or 3rd. You just find out whether the 47, 48 are similar or not. If it is the
Lordship,
same
okay,
case.
same day, Lordship, both were arrested, Lordship, same day, Lordship.
But we have to afford, when it is an NDPS case, we have to hear the PP. Hearing the PP does not mean he stands here and we say heard. We give him the opportunity to see whether
And
it
Lordship,
is similar or not.
Lordship,
2nd, on Monday.
Lordship. Deeply obliged, Lordship.
List again on the 2nd of March. The learned APP shall have instruction whether the matter is similar to BA number.
Lordship, BA number 232/2026.
Since it has been submitted that both the accused persons were arrested together on the same day. And the matter relates to the same offense. Okay.
Item 10.
Deeply obliged.
AP.
Item 10 can be after some time. 10.
Without a notice to the respondent number 2, can I do anything?
Sorry, my son.
We'll send a notice to the respondent number 2.
No, my senior will be preparing for this case, man.
Okay, after some time.
Item 11.
Huh?
Please, Lord.
Hmm.
We are seeking a transit anticipatory bail for a limited period. An FIR was lodged in Rajasthan. FIR pertains to recovery of some payment regarding a contractual dispute. A crane had been taken on hire by my subcontractor. Now the informant is claiming the money for that. And the informant has lodged this FIR very clearly stating that he wants the recovery of this money. So first a handwritten notice was served on me by the Rajasthan police on 14. It was handwritten and the date was given in 21/7. So I did not do anything. Then on 18th of this month, they filed another notice, this time a type notice, asking me to be there in Rajasthan on 21st. I only had 2 days time, so I could not go. Now I intend to go, my lord, in the first week of March to Rajasthan and file a regular anticipatory bail application before the competition court. But my apprehension is that in this transit period or before I could file that application, my lord, I may be taken into custody. So for that only.
transit period only.
Transit period.
Till when?
My lord, for 10 days, my lord, 10 days will suffice.
No, I heard Mr. Swansol and counsel appearing for the petition. Also heard Mr. D.P. Goswami learned APP. It has been submitted that the petitioner has received a notice
Notice they
under
were also
173 BN, no, under
It's 30,
30.
the second one.
Notice under 35(3) of the BNSS asking him to appear before the office, before the police authorities at Kerisle City, Kothawali district, Bilwara, Rajasthan. That you will find in page 31, huh? Down below, okay? The petitioner, the counsel for the petitioner submits that he is ready to cooperate with the investigation since it is a claim for money arising out of a contract. And he is also ready to appear before the competent jurisdictional court to pray for regular bail. Regular bail.
And because this investigation.
Regular anticipatory bail before the jurisdictional court at Rajasthan. He therefore prays that if granted the opportunity to travel to Rajasthan without being taken into custody, he would appear before the jurisdictional court in Rajasthan within a period of 10 days from today. Accordingly, this court deems it a fit case to allow the prayer of the petitioner. So accordingly, the petitioner is granted it is provided that the petitioner shall appear before the jurisdictional court on or before 27/7.
Because it is an anticipatory bail.
Uh.
So I will not appear, my lord. I will prefer an application for anticipatory bail within that period of time. I will appear before the IO. His investigation is pending. So physical appearance before the court will be required.
We were trying to say that you would go and appear before the jurisdictional court by the 10th. And if prior to that, any point of time you are arrested, you would be released on bail.
Only for that.
Till the 10th.
Yes.
If he is arrested before the 10th, he would be let on bail and he would appear before the jurisdictional court on or before the 10th to file his anticipatory bail. Are we very saying something wrong?
No,
Why were we interrupted?
no, my apologies, my lord.
Huh?
I only was under the impression that I was asked to physically.
Remove your impressions. Be
My-
depressed in this court.
My apologies.
Be very depressed and suppressed. It is provided that the petitioner shall appear before the learned jurisdictional court in Rajasthan on or before the 10th of March 2026 to prefer a petition for praying for a petition seeking the privilege of pre-arrest bail in connection with the matter. However, in the interim, if prior to 10/3/2026 he is arrested, he shall be released on bail of rupees on furnishing a bond of rupees 20,000 before the arresting authority, so that he is allowed to appear. Before the learned trial court, learned judicial court at Rajasthan. Anticipated bail petition disposed of. In satisfaction of the arresting authority. Huh?
482 BNSS application,
Hmm.
your lordship. FI is page number 10, your lordship.
Page number
Yes.
10.
Type copy, your lordship. Here, FIR pertains to your lordship recovery of some 33 numbers of gold biscuits, your lordship,
Hmm.
from a vehicle that is Bolero, your lordship. Here we are, your lordship, not the owner of the vehicle. Neither my name has been mentioned in the FIR, your lordship.
Hmm.
How our name has been surfaced in this case, we don't even know, your lordship. But we got to know that the police is continuously harassing me, your lordship.
By
for
doing
arrest,
what?
your lordship. For that reason, we are before this honorable court, your lordship.
Why are they harassing? How?
So the lordship, there is no any materials to show or to convince before this honorable court how I am connected with this case. But 26.
How are they harassing you?
Yes, lordship, 26, your lordship, one message we got, your lordship, that is 26, your lordship. Page number 26, your lordship. Type copy is 25, your lordship.
Huh?
It was a case of Tezpur police station, your lordship. Now Tezpur police station sent a message to Lakhimpur police station, your lordship, that is the concerned police station of the petitioner, your lordship, to arrest these persons, your lordship. That is petitioner number 1. Here, your lordship, last paragraph, your lordship, kindly arrest the accused Ramjan Ali, and that is, your lordship, Nurul Islam. Your lordship, he is the person, your lordship, named as petitioner number 1 before this honorable court, your lordship. And except this, without avowments, I have nothing to show, your lordship. There is in the record, the police is harassing me.
How did you get this?
Lordship.
This is an inter-police communication? Is it not an inter-police communication?
Yes, Bangalmara OP2.
From IC to IC?
Yes.
No copies, marked with SSP. Huh?
It has given to me, your lordship.
Who?
No, the person get it from them, your lordship. From the.
Huh? How can they get it?
concerned authority.
How can they get it? Infiltrating every office.
Without that, your lordship, I have nothing to show you how I am connected, your lordship. In
Yes,
this
we'll
case,
allow
your
them to
lordship.
appear before the IO at Tejpur in connection with that case.
Yes.
Also have Mr. Gogoi here if possible. We'll allow them to appear. All of them will be at the police station. You find out how they could have a reach to this, which is the person who leaks this information.
Yes,
Is it not?
but yes.
Huh? On the next date, we'll see about continuing the AV or not. Because if they do not appear before you, you will have no link.
No link.
Let them appear before you. Let them state before you as to how they have got this document. Who is the concerned person who is leaking investigating papers to
Anything
everybody?
found in the materials in the case diary and
And if the case diary shows that yes, this was the person who is leaking, this is the informant, have him also in the soup.
then we have to we
Because
have
the
to
main
go to the
person-
instruction regarding the police. They have
So we'll take it up after 5-10 minutes. Ask if Mr. Gogoi can be here. Huh? We are bringing this type of cases to the notice of Mr. Gogoi because he's the PP. All of Mr. Debo. Yes, we'll have it after some time.
Rush it, rush it.
Attempt 22 and 24.
Wait, please, your lordship.
Huh?
Lordship, NDPS intermediate quantity, 153 days behind the bars, your lordship. CD was called for, your lordship.
Hmm?
Police said FSL not received, lordship.
FSL. Assuming it is
21.
whatever you think it is. Custodial, further custody explain to us.
Your lordship, FIR is at page number 11, your lord.
Huh?
FIR is at page number 11, your lordship. May-
How are you connected to it?
Your lordship, 2 persons were apprehended by the police in a locality, and from both of them in school bag, they recovered 21 kilos along with the packeting, your lordship. Ganja was recovered, your lordship.
In school bags.
With 2 people, allegedly the said product in which they were carrying was called a school bag. Is carrying in a school bag, your lordship. And 2 persons were there. One was aged 51 years old,
Hmm.
the other being 21 years old, your lordship. And then 21 kilograms along with the packet and the wrappings overall. It is not the only quantity of the contraband which is recovered, not the net quantity, but the gross quantity, your lordship. Thereafter, your lordship, have been forwarded and section 27A of the NDPS Act was attracted. However, in the seizure list, there is no connection with regards to any kind of recovery of money or my connection with regards to illegal trade. There is nothing which indicates that I am financing or a person of with regards to the trade.
It was ganja.
It was ganja.
So 21 kilos of ganja you are proposing to this court that you wanted to consume.
With regards to 27.
So it has to be given to someone. That is trade.
Indeed, your lordship. With regards to 27A, which starts 35.
21.4 kilos itself shows that it is for trade.
Intermediate quantity, your lordship.
It
That's
is for
agreed.
trade.
That is
You
agreed,
could
your
not
lordship.
have taken the whole of it.
Indeed, your lordship.
Yes. Why do you want me in further custody?
Peddler, your lordship.
Intermediate quantity 37 all gone.
Lordship, because in his possession, this commercial quantity has been found, lordship.
Intermediate.
No, it is 22 no, 22 and 20.
22.
Oh, it is a commercial quantity, 21.
21.
Oh, it is a commercial quantity, lordship.
No, commercial is 20.
20. It is in the case the 21C is there.
20B to say.
21K, lordship, page number 2.
C.
He himself stated that.
See, your lordship.
T is commercial quantity, lordship.
Why are you stating it is intermediate quantity?
Lordship.
No, your lordship. 20B to C. My apologies, your lordship.
Huh?
Commercial quantity. My apologies, your lordship. 20B to C. Commercial quantity of ganja, your lordship, not intermediate, your lordship. By 1 kilo, it is commercial.
We even asked you whether you could have consumed the whole amount yourself. You were saying that no.
Sincere
Commercial
apologies. your lordship.
quantity, lordship.
By 1 kilo, it was a commercial. That was what I was about to submit, your lordship. My sincere apologies.
If it was minus 0.900 grams,
Indeed, your lordship. It would have been intermediate, your
then it would have been intermediate.
lordship. That was my submission, what I was
The
supposed to.
point does not work 1 kilo, 2 kilo.
Your lordship, however, your lordship.
When were you arrested?
Your lordship, on 27th of September, your lordship.
27th of?
September 2025, your lordship.
Ah,
Already 153 days behind the bars, your lordship.
In the inventory also, lordship, it is stated that 20.
No, it is commercial.
It's commercial,
Because-
lordship.
FSL would have proved it. Without the.
FSL awaited.
FSL awaited, lordship.
When can you have it?
On 13, lordship.
13, list again on 30th of March, awaiting the FSL report.
Deeply objection, your lordship.
What's the way? See, Gauhati as a
Finding as an item two.
Yes, madam?
দুই নেকি আপোনাৰ? দুই, অলপ অকণ। 23 হ'ল নে নাই? 23?
নহয় 22, 23 একেলগে আছে নি কোন দুটা?
Same, no?
Same একে date যাব 22, 23. You are awaiting the FSL report or something, no? 22 FSL report.
22, 23, both are same lordship. CD
FSL report is awaited. We have fixed it for the 13th.
13 lordship.
Awaiting the FSL report, huh?
Finding as an item two.
Lordship, here is last occasion.
এই যে
Ah.
অফিস নোট দেয়া লordship,
What is the official?
She is the mother of the victim.
We remember.
yes, sir.
We remember because she was given away in marriage. You have
Yes,
put the
yes.
mother behind the bars. We do not know about the husband as of yet, but she's pregnant. No time to, no reason to disallow her the mother. What do you say?
Yes, he is the mother of the victim, lordship.
Huh? Office devs.
We're waiting only for the POXO is there, that's why.
Huh?
The POXO is there, that's why we were looking for the service of notice lordship.
So for the petition, the present petition is
Ah.
POCSO 4 is not applicable.
Present petitioner is,
Mother of the victim and.
you have given away your daughter in marriage. You have allowed things to happen which are not required in law to happen. Then we'll appoint an amicus today itself. We'll have the matter on the 2nd. Can you supply a copy to the amicus today itself? We'll take it up on the 2nd because the respondent number 2, who is the respondent number 2?
Zarina Begum.
And who is the applicant?
Applicant is Regina Begum.
Regina.
Huh. Regina and Jerina is who?
Regina is the informant. Along with others.
Who is the, Jerina is what? How is she connected to the case?
It's not connected. He's probably from the village.
The informant in the present case is a resident of the village of the alleged victim. The petitioner herein is the mother of the victim who has been behind,
10-1.
Bars since
10-1.
10/1/2026. A statement has been made in this petition that the alleged victim is at an advanced stage of pregnancy and requires the attention of the petitioner. Full stop. You call for report. Would you be calling it or would the district authorities be calling it?
Or for a CDR report or anything.
Hmm?
Or for a case diary and report or anything.
No, report regarding the stage of pregnancy.
Lordship.
If it is at an advanced stage, she would require the mother.
Because already there in the FIR lordship that she's 7 months of pregnant.
When is the FIR 12/1? Call for in the CD you will have it, the medical
Yes.
of the victim. Call for the CD list again on the 2nd of March. In view of the fact that the informant is not related to the victim and the mother of the victim is before this court praying for a bail, this court deems it fit to appoint Miss Namata. Huh? 25. Sanjana Neva, she attends the court, no? Give us someone who's regular. Bodhijomoni Deka, B Deka as the amicus in the matter. The learned counsel for the petitioner shall serve a copy of the bill petition on the learned amicus during the course of the day. The APP is requested to ensure that the information relevant to the case is placed before this court on the 2nd of March. The medical report is what we want to see.
Item 12.
Item 12, Mr. Gogoi,
Lordship, I have
in
seen.
the interest of the investigation, we will allow this person to appear before the IO.
Lordship.
You would also have the opportunity to ask him as to how Annexure 4
Lordship.
came to their hands.
In what I suggest, Lordship, my lord may direct the SSP Sunitpur and SSP Lakhimpur.
We will do it after we receive the report from the IO that this is how it has been said to be leaked. With that, we will send it to the SSP. That now you make an inquiry because the IO is also in, he is in the knowledge.
Lordship.
There will be 2 police stations.
Lordship, Lordship.
Let them appear, tell how you got this.
Lordship may indicate in the order.
We'll say that we are granting them the privilege of appearing there on or before the 6th.
Lordship.
We'll fix it on the 12th.
Lordship.
We will record what we have noticed.
And my lord also record that part, Lordship. Lordship.
And how it has come will also be with the record.
Lordship.
And if he is not involved in the
Lordship.
crime of
Seizing of 33 numbers of gold.
that gold biscuit, if you do not, that anticipatory bail will be another part of it.
Lordship.
This leakage part
That
will be another part of it. We wanted your presence therefore only.
So Lordship may direct the OC, Lordship.
You have to also inquire as to how this came to be leaked.
Lordship, and he is directed to place a report before your Lordship.
Along with the CD, a separate report would come.
Lordship.
Heard, Miss
G. Bora, Lordship.
G. Bora. Learned Counsel appearing for the petitioner, who is seeking for the petitioners who are seeking the grant of privilege of pre-arrest bail in connection with.
If I record my brother's name, Lordship.
Oh, yes.
Lordship, I mean, I can go.
Please, we just wanted you to bring it to your notice.
Oblige, Lordship.
In connection with Tejpur PS case number 797 registered under section 316. To page number 1 apa lobo, huh? Ba page number 2 top what ase, huh? The learned counsel for the petitioner submits that though other co-accused have been, though other accused have been allowed to go on bail,
Lordship.
huh? The petitioners are being tracked by the police authorities with an attempt to arrest them. Full stop. So the learned counsel for the petitioners referred to the annexure 4 in the bail petition, which is to the following effect. Huh? Ye page 25, annexure 4 you will quote. Huh? Full stop. Keeping in view the fact that the accused from which the recovery had been made have been granted bail, we deem this court deems it a fit case to allow the petitioners to appear before the investigating authority, that is the IC Borghat OP, Tejpur, on or before the 6th of March 2026 to participate and cooperate in the investigation. In the meantime, it is provided, list the matter again on the 13th of March 2026, full stop. It is provided that in the interim, if the petitioners are arrested, they would be released on bail of rupees, on furnishing a bond of rupees 20,000 each with one surety of the like amount to the satisfaction of the investigating arresting authority, full stop. Now, next paragraph. This court has noticed that the annexure number 4 at page 25 is an inter-office communication from the IC Borghat outpost, Tejpur, to the in charge of Bangalmara outpost within bracket Bipuria police station in Lakhimpur, full stop. The petitioners on their appearance before the investigating authority shall also reveal to the investigating authority as to the source from which they could manage to have a copy of this is what? This is a WT message. Of a WT message, which was an inter-office communication between the investigating authorities. Full stop. A separate report on the manner in which the same was made available to the petitioners shall be laid before this court, along with the case diary. on the 13th of March, 2026. Next up. Please,
And copy of the order to furnish to me, Lordship, I
a
can.
copy of this order is to be furnished to Mr. D.P. Goswami, who shall thereafter forward it to the competent authorities, concerned authorities. Hmm?
24.
Next. Lordship, complaint petition at page 10, Lordship.
Hmm.
There is a recovery of 2 kgs of tablets and 45 grams of sugar.
Huh?
Lordship,
Hmm.
we have a look at NHR 1, page 10.
Yes.
Page 10, Lordship.
Hmm. Two kgs and 845 grams. Okay.
Lordship, in this case, Lordship, 47 and 48 notice not served.
Not served.
Not served.
Hmm. When were you arrested?
He was arrested on 23/11/2024.
23/11.
Lordship.
Yes, sir. 20
DRI, Lordship.
DRI standing counsel টা দিওক scroll টা দি থক DRI I will do
25.
after some time. Let the DRI be here. 20. Hmm.
May I please, Lordship? CD was called for matter. Yes. Trustee submitted, Lordship. But my lord, there is a violation, my lord, of Article 48, my lord.
Article?
Because, my lord, notice was issued on English, man, which is not understandable to that. My lord.
There is no 48 here.
Yes, my lord, page 23.
Page 23.
3.
Yes.
It has been written on English, but the mother of the petitioner, my lord, she received the notice, and the language is not understood by her, man. As per Bihan Kumar, my lord, it should be understandable language.
Yes. Then you will have to bring in an affidavit from the notary himself. The affidavit is in English. You sign it in SMS. You understood the affidavit when it was being signed. Why did you not understand the 48th notice when it was being signed? Whom to believe?
But
The affidavit.
but it was explained.
The affidavit, it doesn't say in a language other than the one which has been, in which it has been drafted. Does it say so? That seal does not say, I read it over. I read it over and explained the contents. And she understood it. The language part is not there in the affidavit.
But if since charge sheet has been submitted, let them make their prayer before the.
I think you should appear before the trial court. Because the charge sheet has been submitted.
That observation may be taken by-
Is it not?
Yes.
Or there is any objection for not releasing him on bail? Should we release him?
Lordship, I am appearing as the amicus, your Lordship.
That is why. Should we release him is what we are asking you.
The Lordship, since the charges has been filed.
Not proper at this
Your
stage.
Your Lordship.
Court of first instance. The learned PP has submitted that the charge sheet has been filed in the matter, and the learned amicus, Mr. T. Devi, has also submitted that since the charge sheet has been submitted, the court of first instance would be the learned trial court. The learned counsel for the petitioner has therefore sought to withdraw this bail application with liberty to approach the learned trial court to pay for regular bail. The prayer is allowed, bail application is closed, liberty is granted to approach the trial court for regular bail, and that said application shall be considered without reference to the dismissal of this present application.
Charge sheet number,
CS number, take the CS
case
number.
number 1414/26 dated 19 January 26.
Published.
So here the petitioner was arrested on 29/12/25.
Hmm.
Today is lordship already, in my calculation, it is 60 days. Charge sheet has not been submitted.
The learned, heard Mr. Swenson, learned counsel for the petitioner, also heard the learned APP, who has submitted that he has not been informed that the charge sheet has been submitted till today, comma, although today is the 60th day. Full stop. Since the charge sheet has not been submitted till now, the petitioner is allowed to be released on bail, allowed the privilege of bail, because we do not know if they've put it up in the afternoon.
No, NDPS case lordship, so lordship may put that he will attend the trial regularly. Lordship.
Conditions would be there of all the NDPS.
That much, so.
The petition is allowed to be released on bail on furnishing, you are of the same locality?
My lord.
Huh? Where were you arrested?
My lord, from the house of the.
On furnishing a bond of rupees 1 lakh with two sureties of the like amount, one of whom shall be a government servant. Full stop. The petitioner shall regularly attend the trial court, the investigation and the trial court as and when required and directed to do so. Full stop. Any violation of the terms would have the bail order liable to be cancelled. We'll put in 1 or 2 more conditions.
I'll do
You will
it,
not
okay.
do the same dealings again.
That can be done.
No?
Obliged.
Scan copy was called for, probably it has not been received. There is a office copy.
26, my lord, it is a 21B, and it's 17 days behind the bar.
Hmm.
My lord, trial has started, I am facing the trial. And moreover, only release recovery of 35 grams of heroin. My lord, what happened? In the FIR, it is the heroin, but 47, 48, they have served me, following the due process of law, there they have mentioned Yava tablet.
Huh?
Yava tablet.
Oh,
Please
and
come
your
with
trial is going on for heroin.
Heroin, actually it was heroin.
Eh?
But they have served me the copy 47, 31 and 32. You will find the suspected Yava tablets were concealed.
No, the heroin was suspected to be Yaba. They had the wrong suspicion.
Malana, besides this, I am praying for that limited time, 117 days.
That is, since this scan copy was called for, lordship, let it come, lordship, then
170 days we are facing the trial. What more
conviction.
conviction to how?
Ha ha. Yes.
I'll
No.
go to jail for conviction.
BA number 261 of 2026. Kindly see the next date. BA number 261 of 2026. Saksu. Huh? Aji ase. Katar listing. So the CD has been received. It is the scan copy has been received. It is tagged with 261 of 2026.
So.
But your lordship, I peruse it, madam, today it's at second half. It's possible, madam.
If the other court does not release the file, can I take it up at 2? Is it not?
Besides that, my only prayer before your lordship, in spite of the illegality has been done 47,
Huh?
48.
Let us do it. Let us do it this way, Mr. Biswas. We'll accommodate you for the 2nd of March. Today, whatever order comes from that court, some order will come from that court. The file has to be released. We'll have the CD tagged here. Now the TCR tagged here. Can it be done?
That when bail will be granted in that case, my credibility will go wrong in that place.
No. On the 2nd of March,
Yes.
we are having
But
The matter fixed.
But also saying out of the same PS, 27 items.
Item 27.
Also,
So we'll have all the three, both of these on the second. Instead of pressurizing that court to have the CD sent today itself, we'll have it on second.
I'll rely up.
The office note records that the scan copy of the trial court record has been tagged with BA number 261 of 20. No, just a minute. The scan copy of the TCR comes through mail. All you need is a printout. Huh? Section of IT we can, but then again, we may have contradictory views on the same. We'll have it on the second. On the 2nd of March. Full stop. Register to ensure that a copy of the TCR is
Well, second,
connected.
I may be out. It is on 4th. Oh,
Fourth, we will all be out.
First
Fourth is a holiday.
First Monday.
First is a Sunday. Second is a working day.
I have to go out other course, but that's the problem.
We can have it on the 5th.
Which date?
5.
Yes.
5th? On the 5th of March. 2026. Huh?
28 Lordship.
Well, at the FIR is page 10. FIR is page 10. Well, at here, the informants will file this affair before the customer appears, stating that, well, the petition number 1 and 2, they were involved with the narcotic drugs, that was recovered from the shop of the present petition number 1. That is the grocery shop, And the present petitioners, as per my instruction, saying that the grocery shop, evening time, so many customers gathering there, and suddenly police come and people played away and on break left there and found that some substance here. The weight is total 9.5 gram.
What is it suspected to be?
Heroin.
Heroin.
Yes,
Your Lordship, the CD has been received. FSL report has not yet been received, and today is Lordship 36 days. So let it
We'll
come
await
out.
the FSL report.
Yes.
We'll await the FSL report till the next week. On the 9th or 10th, we'll have the matter listed. Pick a date, 10, 11, 12, pick a date.
10.
10th. List again on the 10th of.
Let it be on 16th Lordship.
16th.
Oh, then 5th or 6th.
Fifth is not possible.
Either you have suggested 10, he has suggested 16th. We'll go halfway 13th. 13th of March, awaiting the FSL. CD is awaited. 29.
What's the item number?
29.
29 Lordship.
29, I am
He
here.
did not receive. Lordship.
Here in this case, your Lordship will find that I have closed the certified copies. That notice was given to me as well as to my family saying that 21, I am arrested in connection with a case of 21A. No quantity is mentioned. Subsequently, Lordship, when Lordship forward, I will find that I am forwarded in a commercial case. Quantity involving commercial quantity. That Lordship may kindly say page 21 is the notice. It says Lordship 21A.
Page?
21.
It
says 21A.
Mm.
And grounds of arrest in next page, your Lordship will not find the quantity. Page 22. Similar, Lordship, that page 23 also, that notice under section 48. Here also that 21A is mentioned. No quantity is mentioned at page 24, Lordship. No quantity is mentioned in page 24 grounds. And subsequently also in the forwarding report and the document.
That will not be reason enough. 47, 48 that you were found.
Forwarding Lordship, it is mentioned.
That you were found to be involved in
Another.
this NDPS in this big bag and all that, that is there.
No, regarding
Qualitatively, it is there.
No, regarding that ground, your lordship will see that in the FIR, page 11, for a
Hmm.
moment, lordship may kindly say page 11.
Hmm.
So just facts of that case I am placing lordship, that 2% your lordship will find in middle person, staff accompanied are. So this is the 2%. Now after that, this paragraph lordship may kindly see, I along with the aforesaid police party arrived near Baba Hotel bypass by our GOV vehicle Bolero bearing registration number so and so, driven by another. On reaching at the spot, as identified by the source, I noticed one person carrying a bag. On spotting us, he fled the scene, abandoning the bag. Now your lordship may kindly see, this is these two persons are there, source was there. Now, who was that unknown miscreant? That is your lordship will on page 12, name of the accused person, unknown miscreant. They have not identified me or at the initial point of time because the FIR was lodged belatedly after 12 hours. Even then, my name was not reflected in the FIR. Now, your lordship may kindly see that page 47, notice under section 47, page 22. It says that they have identified that source who was present at the place. They have disclosed my name. What prevented them to disclose my name after 12 hours, lordship, of lodging of the FIR? Page 22, ground number 1, lordship may kindly see. The reason is that the source identified. Because I was arrested subsequently.
What happened to the earlier NDPS case?
He was granted bail. He is on bail in that.
He is on bail.
He is on.
One of the conditions in that bail being that he should not be involved in any other future other activities.
No, lordship, if your lordship finds lordship he is involved in the present case, then that bar will come. And merely lodging of the case is not sufficient that I can place before your lordship. Judgment.
Lordship, the
But in the
petitioner was, page 14, lordship has already see the 2 persons after lordship, inquiry lordship, they identified this person. The death takes time, lordship. FIR was lodged prior to death.
Hmm.
After he was identified, he was arrested and forwarded, and all these grounds are there, lordship. In any case, lordship, CD is not
Lordship-
before the lordship.
lordship may kindly
Lordship will
pay-
fix a date, will produce the case date, lordship.
Lordship may kindly see page 9, because lordship, the time of incident is shown to be 10 AM morning. And FIR was lodged at 10:15 PM in the evening. Even then, source and the police personnel did not disclose my name.
A
After
bad
12
source,
hours.
very bad source, but does not entitle you to the bill as of
In
today without the
notice-
CD.
Notice of-
Without the CD, it does not entitle to a bail today. If the CD is here, we can then consider.
Lordship may give
in this
short
case.
date, lordship.
We'll give a short date. Yes, when?
From Sri Bhumi, lordship.
Huh?
As per your lordship's direction, lordship. I'm
13th. 13th of March, awaiting the CD. List again on the 13th of March, awaiting the CD.
Obliged.
Elementary item Article 50.
Item 50 কিবা এটা কৈছিল নেকি ৰাতিপুৱা? কোনটো আইটেমত কৈছিলে? সাপ্লিমেন্টাৰী কিবা কৈছিলে?
50.
Oh, no, 49ত কৈছিলে ন? 50.
50, lordship, it's a POCSO case, appearing, respondent number 2 is appearing. What I have seen from the records, lordship, the charges has been framed, the victim has not yet been examined.
Where is the?
Yes. And he's a resident of Madhya Pradesh, lordship. But you will find all the materials at page 37. Petitioner is also not before a lordship.
None appears for the petitioner on call. The trial court records reveal that the evidence of the victim has not yet been taken. List again on the 20th of March. Call for the, in the meantime, in the meantime, call for the updated trial court record.
23rd of March, before the trial.
23rd of March. Then we'll have it on the 30th of June.
Yes.
On the 30th of June, the updated scanned records of the trial court, if statements of witnesses are recorded, be sent.
30th of March.
What did I say? June. Longer the better. The FIR says longer the better.
Item 41.
Yes.
So, my lord, in this case, my lord, in the last occasion, interim was granted.
Hmm.
But I could not contact my petitioner because my mobile is also switched off. I also sent people, my lord, but I could not.
He is delivering things otherwise.
Lordship, otherwise, he is on interim. And Lordship, the CD needs to be updated because one report was called for that has not been received.
He has not been able to contact his client.
Yes. Yes.
Therefore, the client has not appeared before the IO.
Oh.
We had given the liberty. We withdraw the liberty. Heard Mr. M.A. Hussain, learned counsel for the petitioner, also Mr. B. Sharma, learned EPP for the state respondent. By the order dated 4/2/2026, the petitioners had been granted an interim protection, allowing them to appear before the investigating authority to participate in the investigation. Mr. Hussain today submits that despite his best efforts, he has not been able to contact his clients, and the mobile number given by them are also found to be switched off. This does not.
Send message, my lord.
Huh?
I also sent message.
The learned counsel for the petitioner had also sent messages which have not been replied to. Full stop. In such circumstances, this court is of the opinion that the petitioners may not be acting bona fide, and therefore the privilege of pre-arrest bail granted by this court on 4/2/2026 is hereby withdrawn. Do we need to continue with this bail petition or should we close it at all? Since the petition
Merit, my lord, otherwise, as per the CD.
No, we'll do it today itself. Since the petitioners have not cooperated with the orders passed by this court and have failed to be even in touch with their learned counsel, it does not appear to this court that the petitioners are entitled for the grant of pre-arrest bail. In such circumstances, this anticipatory bail petition is dismissed. Let them not play with the court. Three of them, none in touch with you.
No, my lord, only one was contact with me and the number is there who has executed the affidavit. I called him, I sent people also, my lord.
Hopefully, they'll have contact with you by Monday.
Maybe, my
Yes.
lord.
32 CD not received, Lordship.
List again on. Are they on interim or something?
Not sure. Lordship.
None appeared for the petitioners on call on 21/1/2026. None appears today also. This court had granted an interim protection on 16/12/2025. Full stop. We'll take it up at 2. Find out whether they appeared or not. Forget the city.
Lordship.
If they have not at all appeared,
Lordship.
then what has happened to the earlier case is going to happen to them.
Lordship.
You keep this part. This thing, huh? I will have to remember.
That's it submitted, Lordship.
Yeah, please.
And they are on interim, Lordship.
Complied with the order passed by his appeared.
Huh?
I have complied with the order, my lord, passed by this honorable court, and I have appeared before the IO and recorded the steps.
Learned counsel for the petitioner submits that the petitioners have appeared before the IO and participated and cooperated in the investigation. Learned APP has submitted that the matter has been charge sheeted by CS number
178/25 dated 30 December 25.
In connection with Biswanath Chayali PS case number 213 of 2025. Stop. In such circumstances, the interim bail granted to the petitioner is hereby made absolute. Petitioners at liberty to approach the learned trial court if and when they receive summons to attend the trial.
Deeply obliged.
Be disposed.
Six.
My lord, in this case, 36, my lord, your lordship granted interim bail and
We are on 35.
35, my lord.
Hmm.
Then when he approached before the police, my lord, he found, my lord, on the same FIR, same allegation, same informant, everything same, my lord, but just another PS case number was registered, my lord. Therefore, my lord, he immediately filed, my lord, this 35 item and
Where is 36? Same person.
same person, same everything.
Why are you doing this?
Lordship, the person has given to the prayed before the CJM Lordship.
He has,
Silchar.
huh?
Silchar.
Huh.
Consider it as a zero FIR, Lordship.
No, earlier also, my lord, it was 0 FIR.
Kindly see. Let us have the two. You have the two cases before you, the two petitions.
Lordship.
Then you come to page
Item 36.
item 36. We are at page 14.
The same Lordship, but I have only the CD of 1170.
One case, one investigation.
Lordship, but
One
I-
incident, one investigation. You may have 33 FIRs on that.
Lordship.
Huh?
No, it is there. CD is there, Lordship.
So tell us.
According to this, Lordship, I want to. Lordship, may kindly go through this.
Oh, yes.
Everything is written in there, Lordship.
Kindly have Mr. B. Gogoi here. B. Gogoi, additional AG and Standing Council Health. There was a matter of this sort earlier. I forget a writ petition or a bill petition. Where similar allegations were there, the person was running for his life because of these kind of allegations that Council of Alternative Medicine cannot be recognized by the NMC. The NMC is for allopathic. These are for alternative. So you want to say that Ayurvedic has got no role to play?
No, but he, according to some rules, Lordship.
According to the NMC rules.
Lordship, but he
But
can.
what about the Council of Alternative Medicine rules?
Lordship,
What will be applicable to him?
it will not.
A citizen cannot be stopped for voting, but the non-citizen can be. Rules are different.
Lordship.
NMC different and Council of Alternative Medicine different. Therefore, we are asking you to have Mr. B. Gogoi here.
Lordship,
We remember a discussion where it was said that these FIRs are being lodged on a wrong notion because they are not in the register for practitioners who have passed out from the regular medical colleges. They have got different registers. One for the allopathic and one for the alternative medicine. And because the allopathic did not know that there is something called an alternative medicine, you might remember that case, this one person, he was doing this medicine business, his son and wife also died. He was arrested, harassed, he lost his job, everything happened. Then it came out that the FIR was lodged on a wrong notion by the NMC.
I will call him.
By the anti-quackery. Anti-quackery is from the NMC.
Lordship.
But alternative medicine is allowed.
Lordship.
So we'll have you take back your CD.
Lordship, I will call.
Ask him if he can be here at 2 or earlier also. No problem. CD con ghudai. We'll take it up after some time, sir.
Lordship.
That is your case. You are qualified from the Alternative Council.
Even otherwise, my lord, he is now already appointed as a, my lord, teacher, primary teacher in the year 2017, my lord. Therefore, my lord, he is not in this well.
No, did you put someone at risk by giving him medicines? Alternative medicines? That we have to see. We'll see the case diary then. But ask Mr. Gogoi, yes, next.
Item 37. Statement 9. Statement 1. Update.
Here we are on interim, my lord.
Hmm.
I am on interim, my lord. I appeared before the IO 5 times, my lord.
Hmm.
Now, my friend is saying that my statement is not recorded.
That was not there on the earlier occasion also.
One last one, Lordship, I will personally communicate, Lordship.
Certified copy to send letter.
I will communicate with Lordship.
Certified copy to send letter.
কি হবে?
Order copy to send letter.
No, বাকি সব আছে। Lordship, I will communicate.
That is suffice, my lord. I have
Lordship, I will personally
certified
communicate.
copies is there, so I that is the proof, my lord.
The CD is awaited, huh? No,
Not
the
the
CD
CD,
has, the CD has
not
been
updated,
received,
but-
but without the statements of the petitioner recorded. Mr. NJ Dotto has submitted that the petitioner has appeared at least 5 times before the IO, full stop. List again on the 20th of March, allowing the learned APP to have the updated CD.
Right.
Full stop.
I'm offline.
I will personally communicate.
It's the petitioner's interim, my lord, and after interim, my lord, the petitioner appeared before the IO, my lord. And in the meantime, my lord, the opposite party number 2 has filed an affidavit, my lord, annexing an agreement, my lord, page 28, starting from page 28.
Respondent number 2, you are appearing? Yes, what do you say?
One affidavit has been filed by the assessor.
Saying what?
Saying, my lord, the
Misunderstanding, my lord.
Then for lodging a false case, then we have to,
There is about 20 years. Yes, my lord.
when was the FIR lodged?
FIR lost, my lord, 2nd of January. And the agreement executed, my lord, 10th of January. Immediately after 8 days.
What executed agreement?
The agreement.
What kind of an agreement?
The agreement said, my lord, the case was lost out of misunderstanding. Then, my lord said, my lord, parties do not have any allegation against the second parties. Again said, my lord, both the parties have come to compromise willingly on their own wish.
Hmm?
Paragraph 2 and
Whole
Four
system is running with that case. Investigation, other parts.
No, we'll have the investigation, we'll have a prosecution launched. Where is that POCSO Act? False cases being lodged, we'll have the prosecution initiated against the lady. We can direct it to be done because of the affidavit now.
And as per FIR, my lord, allegation about prior to 3 years ago.
Yeah.
And my lord, as per FIR, my lord, the incident occurred 3 years ago.
As a major, she has lodged an FIR.
Yes,
As a major,
yes,
when she was 19 years old. Yes?
yes.
Then she now tells the court, okay, sorry, dimag kharab ho gaya tha, de diya. So her anger will give her time to cool in appropriate place.
He has nothing to say. Lordship will try to facilitate him also.
Hmm?
He has nothing to say. Lordship will try to facilitate him because the informant is concerned. She is lodging an FIR against the petitioner, Lordship. And now he is saying something different.
The informant.
Yes.
Where is that? Fake cases.
Section 22(1), Lordship, punishment for false complaint or false information against an adult. Punishment for false complaint or false information. 22.
Then for carrying out 22, what is the rule? who? Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. D.P. Goswami, learned APP, and Mr. learned counsel appearing for the respondent number 2, who has been duly appointed by the respondent number 2 through a wakalatnama. The contents of the FIR in regard to Bilasipara PS case number 14 of 2026 under section 64/49 of the BNS, read with section 6, 14 and 15 of the POCSO Act are as follows. You will take it from page number 9. Accordingly, the investigation was launched, and since the petitioner's hearing were named accused in the FIR, they had approached this court praying for anticipatory bail. By the order dated 22/1/2026, this court has taken into consideration the fact that on the date of the alleged incident, just a minute, that the accused was a student undergoing studies, and the accused number 2 and 3 were government servants. Keeping such matter in view, this court had granted an interim privilege, allowing the petitioners to appear while awaiting the notice on a service of notice on the respondent number 2 and the case diary. Today, Mr. Islam, your name is Mr. Islam?
Yes.
Mr. Islam has drawn the attention of this court to an affidavit filed by the informant, by which a statement has been made that there was a proposal of marriage between the informant and the petitioner number 1.
Paragraph 5.
Between the petitioner and the informant petitioner number 1 and the informant, but the same could not materialize. Full stop. Therefore, in anger, the father of the informant had forced her to lodge an FIR on 2/1/2026. The parties again met on 10/1/2026 and accordingly executed agreements. Full stop. The statement of the victim recorded by the JMFC Bilasipara is to the effect that the FIR had been lodged out of anger, and now that her head has cooled down, now her head has cooled down and the accused had not done any bad work. Full stop. In view of the above, the interim protection granted to the petitioner now stands made absolute. Full stop. However, this court notices that an entire process of law had been set to motion due to the mere anger of the father of the informant and the informant herself, who were both major at the time of lodging the FIR and setting in motion the process of law only to satisfy their anger. Full stop. Section 22 of the Protection of Children from Sexual Offences Act 2012 provides for punishment for false complaint or false information being given. With regard to acts which are prohibited under the POCSO Act of 2012, full stop. The learned court of, where from this have come?
SDGM Bilaspura.
The learned court of the SDGM, Bilasipara,
Bilaspura. And
shall take note of this order, comma, the statement made by the victim on 12/1/2026 before the learned JMFC, and also the agreement placed on record before this court, and the affidavit placed on record by the informant, and initiate appropriate proceedings as required in law, including committal of the case to appropriate courts if so necessary, and see that etc. in compliance of the requirements of section 22 of the POCSO Act of 2012. The copy of this order be sent to the court of the learned JMFC, Bilasipara, to the registry. The learned APP shall also forward a copy of this order to the concerned investigating officer in Bilasipara, PS case number so and so, for his doing the needful. A be disposed of.
God bless.
Our expectation is no mercy in these cases.
Item 39.
But we have not.
Yes, sir.
Petition of interim lordship appear before the IO lordship.
Have not received the case diary.
And after lordship is right.
Who restrained? You restrained someone. Huh?
Petition, yes, lordship, against to be
Why did you use a knife and all that?
lordship.
Huh?
Annual page lordship 14.
Hmm?
FIR 14.
Yes. দুই নম্বৰ সাগৰ গাঁৱৰ পাপাবৰী চকৰ নিজৰ গ্লেমাল, what is glamal?
I think it's.
Third line from the top, 14, page 14, you are making us read. Glamal
Galam means grocery. Galam.
বন্ধ কৰি টকা পইচা লগত লৈ মটৰ চাইকেলেৰে নিজ বাসগৃহলৈ উভতি অৱস্থাত উত্তৰ ৰাস্তাত কোনো লোক নথকা সুযোগ লৈ উল্লেখিত নম্বৰ 1, 2, 3 পদকীয়াখনে আগভেটি ধৰে, কাণে মাৰা উদ্দেশ্যে মাৰপিট কৰি মোৰ লগত থকা 18,000 টকা অস্ত্ৰ দেখুৱাই কাঢ়ি লৈ যায় ঘটনা সন্দৰ্ভত। So you are an interim.
Not case diary not received.
CD is awaited. List again on the 25th of March. Interim protection granted earlier continues. Yes,
Problem.
I'll just come back 2 minutes. Huh? Yes.
Item number 40.
Huh. No.
May I please go? I'm appearing on behalf of Mr. M.E. Model, concern of the other side, my lord. May I seek for an adjournment for that?
We have received the case diary.
You were on interim, my lord. You have also appeared before
The
that.
case diary has been received. Some difficulties expressed on part of the learned counsel for the petitioner. What was the FIR about? Have you seen? No. Release this matter again on 13th of March. Or should we make it absolute? Huh?
Before that,
Can it be on-
we have to send back the CD and third number.
Oh,
Can it be on second, my lord?
on the 2nd of March.
Interim, my lord.
Retaining the CD,
Okay.
interim order continues.
God bless.
Yes.
Item 41.
This call for my lord.
Hmm?
We have received a case, right?
The FIR is at page number 16, my lord. It's a vernacular one, my lord.
Yes.
We are disputing the age also, my lord. So that, age of the girl because reflected in the.
মুসালি বয়স 17 বছর আমার ঘৰৰ ওচৰ ইব্ৰাহিম নাম লৰা মানে বেয়া ইংগিত দি থাকে He's a resident of where?
I am the petitioner is the resident of Hatigaon and
Of Hatigaon.
and victim is from Botahguli, Pandabari. So in the FIR just said that I am studying nearby the house. There is a love relation between the alleged victim and the petitioner, my lord. And suddenly the parents of the alleged victim did not want to give marriage to the petitioner, to the victim to the petitioner. And this
Correctly so. Why should they go to jail because you are falling in love with someone? She's not 18.
There is actually what is stated in the FIR, nothing has happened, my lord. But there is a quarrel between the mother and the petitioner. As he went to meet the parents, my lord.
Yes, what does your CD say?
The allegation is lordship, the first accused person is that
Trespass.
he had been continuously and making sexually objectionable remarks against the. Yes, yes.
We'll let him,
17
we'll let
years.
him appear.
Yes.
We'll let him appear. Have some counseling.
But
And
unless he is implicating, he has, as per her 182 statement, but
POCSO is not involved.
yes.
Is it not? Although it should have been. The CDs received by the learned APP to facilitate the investigation. This court deems it fit to allow the petitioner to appear before the investigating officer on or before the 6th of March 2026. The updated CD be produced before this court on 20th of March 2026. In the event of his arrest, the petitioner shall be released on bail of rupees, on furnishing a bond of rupees 10,000 with 2 sureties of the like amount, full stop. He shall also, he shall also give an undertaking before the IO that he would neither visit the locality of the alleged victim, nor have any conversation with her, at least till the next date fix.
Finding item number 8. Lordship has gone to the case by yesterday.
This is inside, man.
He's inside the Rihan Bar.
38 days, almost 40 days, man.
Allegation against collecting money from investment pattern, lordship. Two accused, main accused are their lordship. He is one of the agent of them, lordship.
What about the main accused?
They are released, bail. I have annexed the bail order.
Heard the learned counsel appearing for the petitioner, also heard the learned counsel, or also the learned APP. The CD had been before this court in connection with another matter and had been produced. It has been submitted by the learned counsel for the petitioner. The main accused have been already released on bail and their bail orders have been annexed to the bail petition itself. The learned counsel for the petitioner has submitted that the petitioner would fully investigate with the, fully cooperate with the investigation and the, later on, if he's put upon trial, he would also participate in the same in view of the above. And keeping in view the length of custody of the petitioner, this court is of the opinion that the petitioner can be released on bail on furnishing a bond of rupees 30,000 with 2 sureties of the like amount, one of whom shall be a permanent resident of the locality within the investigating officer. Jurisdiction of the investigating officer. Full stop. The learned trial court, the learned jurisdictional court shall be entitled to, or shall be entitled to impose such other conditions as may be required to ensure the presence of the petitioner in the investigation and later investigation process for the time being. Charge sheet is not submitted. In the investigation,
Hello, it is
be disposed of.
additional session judge FTC Sri Bhumi.
In additional session judge FTC, so in connection with
Yes, sir.
in connection with PS case number. That paragraph is always to be there, huh? Kivi?
Badarpur PS case number.
Badarpur
48 of
PS case number, huh? That one paragraph, na?
Under section so and so.
This is a petition under section so and so. no? Always keep that. section. মাতি দিয়া। এইটো চলাই দিয়কচোন অকমান গৰম উঠি গৰম উঠি আহিছে চলাই দিয়কচোন। হা?
Then Lordship, may I place this order, Lordship? This is under 65(1), Lordship, which is not maintainable. And Lordship, the coordinate bench, Lordship, on that issue was adjudicating, Lordship, and amicus was also appointed, and it came to that conclusion, Lordship, that is valid, Lordship, it is not maintainable. Lordship will see, and amicus was also appointed to assist the court on that issue, Lordship. And Lordship, it is an express bar that is contained in the CRPC or the BNSS. The
The
other,
learned APP has placed before this court.
Lordship,
The
in the morning, they had prayed for the senior to come, Lordship. So let it be passed in their presence, Lordship.
No, we were just going to say since none appears, we'll have it on some other day. Anyway,
No, Lordship,
call it for the second time. Huh? দুটা বজাত এবাৰ মাতি দিব।
Lordship, I will not be present in the second half, Lordship.
Hopefully we are present.
Orders item 42.
My lord, here steps have been taken again, my lord, fresh. Now there is an order, my lord, of 31/26. To ensure, my lord, by the my lord, prosecution, whether these my lord steps have been served on the respondent, my lord.
Do you have any information on it, Mr. Goswami? Or sometime later? Huh?
Petition like. Last order to must have other issue. Petition. 11 of the 26. Single petition.
What is your exact ground for the appeal?
In fact, I have to go through it, my lord. It's a 2016 case, my lord. I am only on service on notice, my lord. Perhaps take this into.
Anyway,
My lord.
when can you have it?
In fact, my lord, my ground would be that, my lord, she does not come within the definition of child, which is contemplated under, my lord, POCSO Act. So, my lord, she is beyond that, my lord, age limit, my lord. So therefore, her consent, my lord, will matter in this case. If she is a child, my lord, her consent will not matter.
Will not matter.
Yes, my lord. So therefore, on that count, my lord, my submission would be that it's a consensual, my lord, physical attachment, if any, my lord.
Steps to get
Steps to launch the most just through training. Those in the police station or trade laboratory. Through police station. Last order was.
Okay. So we'll take an instruction regarding the service of notice.
At two?
At
When at two?
Yes.
Huh? What was he convicted of?
Yes, my lord.
Uh,
Yes, he was convicted, my lord. 7 years, rigorous
No,
imprisonment.
what was he convicted of? POCSO.
Under section 4 of the POCSO Act, my lord.
4.
4, my lord.
Okay. Can we have it at 2 or something? This thing. At least we can then fix it up for hearing or something. The TCR is here, everything is here. Take up the matter whether he needs to languish in jail or not. অলপ পিছত মাতি 2টা বজাত মাতি দিব। None appears for the appellant on call. List again. We so want to say at the convenience of the registry on 27th of March, 2026.
Item 44.
LCR আহিছে নেকি?
Not a right.
LCR call for by the order dated 29/9/2022 has not yet been received. Issue reminder. List again on 30th of March 2026. None appears for the petitioner on call. There is an interim order keeping the further proceedings in GR case number 14956 of 2013 pending in the court of the learned JMFC Kamrup Metro Gauhati in suspension, full stop. If on the next day there is none to represent the petitioner, this court may take such absence to be willful and interim orders passed earlier may be modified.
Item 45.
Yes.
May please, Your
Ah,
Lordship. But the OP number 2 not appear. The steps has been taken. But till today, the OP number 2 not appear. So Your Lordship may appoint the MA Custodial. The second time.
what is it against?
Disclosure wait
Huh?
the second time.
What is the, where is that FIR? Whether we can proceed
My lord.
in the absence of the informant. You are?
I am the petitioner, Your Lordship.
Yes, what is wrong?
What is wrong? Your Lordship, one Maya Padra, Your Lordship.
Ah, she committed suicide, she left behind a
Committed
suicide
suicide,
note
Your
with your name. What is wrong?
But see, I have committed some official work, Your Lordship.
Huh?
That is why I have filed.
There are ways and means of doing it.
So-called notice, Your Lordship. Thereafter, suddenly, the one Maya Padra, was headmistress, Your Lordship, committed suicide, Your Lordship.
Suddenly.
Suddenly, madam, whatever, I don't know. I am the officer, Brock Immigration officer, Your Lordship. I have done my part,
Those are things in the trial. Tell us,
my lord.
tell us why cognizance of the charge sheet is wrong. Just tell us that this is why the FIR is wrong, this is why the charge sheet is wrong.
Hire is illegal, Your Lordship. I have not done any intimation or
Evidence,
by
evidence.
Your Lordship,
Evidence,
my lord,
part of evidence
lord,
that you were not responsible for the death.
my lord.
Tell us why is it wrong? Why is a criminal revision petition pending?
Because Your Lordship, service report not yet come.
Very true. Why should, why?
Number
If,
2,
if we find there are not enough grounds
my
for
lord.
us to entertain this, convince us prima facie that yes, there is something to be done.
My lord. Let the matter be heard, Your Lordship, by fixing a date, Your Lordship. On the
Hmm?
day I shall place the matter, Your Lordship.
Someone takes their life saying that you two persons have harassed her. Whether the harassment was to the point of her taking life or whether she was extra emotional is a matter of evidence and the trial court. Why are we looking into it?
That is, Your Lordship, evidence on record, Your Lordship. There are nothing, Your Lordship. Your Lordship will say that I have in the on bail, Your Lordship. Your Lordship will see a fire, Your Lordship, 26, Your Lordship.
Hmm?
One Maya Upadhyay committed suicide, then the husband of the
wife, your lordship. Highly.
What is wrong? On what ground are we supposed to exercise our revisional jurisdiction, sir?
Your lordship will find ground, your lordship. Page page 13, your lordship, and clause 8, your lordship. What did the section 35 so and so which says that the police officer shall in all cases where the arrest of a person is not required under subsection 1 issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other places as may be specified in the notice has not been complied with. Neither the petitioner has served with any notice, nor was he heard before being arrested by the authorities. The petitioner was holding the post of block elementary education officer in the Department of School Education of the state government, and as such was a gazetted officer. Therefore, the petitioner was holding a respectable position in the society.
Yes, sir, do you find anything for us to interfere?
No, because in the suicide notice also there.
What is your ground? Why should we exercise our revisional jurisdiction, sir? Tell us.
That is why you lordship will, it is a hearing matter, you fix it, that you lordship on that day, I said, like that.
Place the matter again on the 30th of March, 2026, awaiting the service report regarding the respondent number 2. It is made clear that there is no stay operating in the matter, and the learned trial court may proceed in accordance with law.
Supplementary list, item 51.
Yes.
Lordship, service report was awaited. We had taken fresh steps again. To be seen.
What is the matter regarding?
Your Lordship, the matter basically pertains to a very controverted set of facts, Your Lordship.
We trust you to make it very simple for us. Why should we?
I will attempt my best, Your Lordship.
Yes.
The petitioner in the present case had initially filed an FIR against a person called Chandan Pathak under section 376 IPC, Your Lordship. Then the proceedings started. Then in that particular case, the accused had taken a stay from this honorable court and had gone away. Then his brother, Chandramani, who is the accused in the present case, files a case against me under section 420 IPC before Paltan Bazaar, White 450/23 PS case. And upon that, a charge sheet or final report is submitted. But then upon filing a protest petition, the present opposite party gets it reverted back and a CR case is therefore registered against me under 420 IPC. Whereas I am the original victim who had filed a case under 376, Your Lordship. Now I am being asked to appear in a case under 420 based on the complaint by the brother of the person who is allegedly harassed for money or something, some other thing. He had filed an FIR in that regard, and the criminal complaint case is also going under his name, although on what grounds I'm not sure. Because the person concerned, the accused person, has all the locus to go file the complaint himself. But then after the final report based on the protest petition filed by the brother of the person who has allegedly
that complainant he was not accompanied by the brother when the complaint was lodged.
No, Your Honor.
Some third party comes and puts in an narazi.
Yes, the brother himself has
How?
filed it.
How someone unconnected with the entire FIR can come and put a narazi and then the matter can be reverted? Where is the order?
Your Lordship, the petition is at page 56. I'm not.
And the order passed will, your lordship will find at page 61.
Now WhatsApp messages are being registered as PS case. Area pending person.
And
Have you seen page 48? Kindly see page 48. Yeah. This kind of informations are becoming FIR. Yes.
And your lordship, this is not just the only case. In Uttar Pradesh, in their own domicile, they have filed a number of cases against me, most of which has been dismissed either during FR or by the court itself while taking cognizance, your lordship. Now, the original case that I had filed under 376 for my grievance, that is under stay, your lordship. But I am being pursued for a 420 case, your lordship. That is the irony of facts here, your lordship.
Where is that Narazi petition?
On
Protest petition, yes, 56. No, page 70.
56, your lordship.
56.
And the same involves just conjecture.
No, he's the person who gave the FIR. The brother.
Yes, your lordship.
The brother gave the FIR, he gave the
Protest petition.
protest petition.
All further proceedings have not been initiated by the main accused in the 376 case, which is Chandan Pathak, but his brother, your lordship. That has been maintained throughout.
None appears for them.
Your lordship, we have taken steps repeatedly. Even in the case where he has a stay, your lordship, he's not appearing.
Huh?
Even in the case where he has taken a stay on the 376 proceeding, your lordship.
What is that case number?
Currently, I'm not remembering. Lordship. Like that.
Where is that case number?
That case is not overseen by me, your lordship.
You had to take steps by WhatsApp or email, did you?
We did, your lordship, but then again, our number, since we had taken earlier, your lordship, our number was blocked, so nothing panned out.
No, we didn't understand what.
We had taken the steps earlier through WhatsApp as well, your lordship.
What about that paper publication?
Paper publication, we have not done. We
There was
had
a
done it through jurisdictional police.
no
As per
registered proceeding, then unserved, out of station. Petitioner may take steps to issue notice through paper publication. That was on 25/7/2025.
Yes, your lordship. At this stage, your lordship, whatever relief we are asking for does not prejudice the other person anyway, your lordship. I am a school teacher, your lordship, and this case, if I am required to appear and then if I am asked, placed under custody, would place my entire career in jeopardy, your lordship. But if your lordship stays the operation of that case, CR 6.
So what do you say? She files a complaint. Then the other fellow files a complaint. Brother of the and that is proceeding, and the complaint by the lady is on stay. We'll keep them at par. But how do you serve copies on the? You have to take the paper publication part.
We will do it, your lordship.
What, Mister? You are Mister?
A. Mishra, your lordship.
Learned counsel appearing for the petition. I also heard Mr. So and so learned counsel. Additional public prosecutor for the state. Did you take steps by speed post for the last order?
Registered poster.
The No, your numbers were blocked is, you sent it to that number, known number.
We will try with a different number. You're talking.
Then he must have given his number in the other police cases. A known number, is it not?
We'll have to take the information from the jurisdictional police themselves, your lordship, because since he has not appeared, we don't know any counsel
No, no,
appearing
no,
on
no.
this behalf.
No,
It has
the
been-
other cases that he has appeared, that protest petition, when is it of? Protest petition is of when?
It was filed
Page
7th
50,
September 2020.
56.
56 must be supported by an affidavit.
Yes, your lordship. Number is not there, your lordship. Affidavit is on page 60.
This is on 2024.
Yes.
Without the phone number, how it was accepted?
Trial courts,
Huh?
trial courts generally.
Trial courts generally
Yes, your lordship.
will
Generally,
override what has
counsel-
been given as a,
Generally, the councils provide their number, your lordship.
where is it?
That outright answer.
Where is the council's number?
The name is there, your lordship, but the number is.
No, it is there,
It's
At
filed
page-
with person.
page 56.
Yes, your lordship. These are the numbers that we have tried, your lordship.
Send it to the register, your own number. File an affidavit that we had sent the message. Why is that affidavit not on record if you want the process to go on?
We were
If they
attempting-
have changed the numbers, not your fault. We'll proceed.
I understand.
The petitioners are directed to take fresh steps as directed by the order dated 21/1/2026 again through speed post and through electronic mode as well on the numbers made available by the respondent number
Two. No,
two
one.
in the protest petition.
Respondent number one, your lordship.
Respondent number 1 in the mobile numbers provided in the protest petition and the email address also provided in the same protest petition, which is available at page 56 of this petition. Full stop. List again on the 30th of March. Till such time, Till such time, no, we'll not keep it early. Till such time, the proceedings in. Yes, what is the
23rd.
23rd
23rd of March.
23rd of March, 2026. Till such time, the proceedings in CR case number 616 of 2024 under section 195 of 384 IPC pending in the court of learned judicial magistrate first class Kamrup Metro Guwahati Assam shall be kept in abeyance. Full stop. Further continuance of the interim would be further continuance of the interim would be considered on the appearance of the respondent number 1. Full stop.
Deeply obliged, your lordship.
You want it to be listed along with the other case. You should have had the details.
Lordship.
The other case,
Yes, your lordship.
if you had it listed together.
I will talk to the council, your lordship. I will get that listed. Remove the sticker.
Next.
Obliged, your lordship.
Yes, sir.
It's regard to the, my lord, Jimma of a vehicle
Hmm.
in a NDPS case. my
Hmm.
lord. So my last occasion or my submission was that it is covered by this case. my lord.
Hmm.
Later on, my lord, one judgment came before the, from the honorable court, my lord. Can I?
Denash.
Then,
Denash, we have it before us. Yes.
Denash, my lord, lordship, kindly have a look, my lord. Paragraph 10, my lord. Paragraph 10 of that, lordship had got that.
Paragraph
Paragraph
10
10.
as per contra.
Yes, my lord. Learned Council representing the state supported the impugned judgment and urged that the judgment in Vishwa de Supra did not consider the import of the rules of 2022.
Hmm.
So this rule 2022, my lord, it says about confiscation of the vehicle, my lord.
Hmm.
Now, my lord, the lordship will now turn to paragraph 27, my lord. Internal page 20, paragraph 27, paragraph 27, my lord.
Hmm.
On the contrary, the rules of 2022 restricts the mode of disposal of seized conveyance to tender or auction as may be determined by the Drug Disposal Committee. However, this restrictive procedural framework must necessarily be read in harmony with the parent statute. The rule being subordinate legislation cannot override or curtail the substantive right and procedural safeguard envisaged under the present legislation, that is the NDPS Act.
Hmm.
Now, my lord, and again, my lord, paragraph 28, my lord.
Hmm.
Moreover, section 36C and 51 of the NDPS Act expressly make the provision of the CRPC BNSS applicable to the proceeding before the special court insofar as they are inconsistent with the provision of the NDPS Act. So CRPC or BNSS will follow, my lord.
Hmm.
Now, paragraph 29, accordingly, we have no hesitation in holding that the rules of 22 cannot be interpreted as divesting the special court of their jurisdiction to entertain an application for interim custody or release of seized conveyance under section 451 and 457 of the CRPC. The authority of the special court to pass appropriate order for interim custody during the pendency of the trial, as well as to make final determination upon its conclusion, continues to operate independently of the disposal mechanism emphasized under the said rule. Any interpretation to the contrary would lead to anomalous and unjust consequence by depriving bona fide owner of his property without judicial scrutiny of an opportunity of hearing, an outcome wholly inconsistent with the statutory scheme of the NDPS Act and contrary to the fundamental principle of natural justice.
Hmm.
So, my lord, in Vishwavidya, my lord, there are 4 scenarios, my lord. But the Honorable Apex Court has held that, my lord, these 4 scenarios are not, there may be another scenario also. So, in that 4 scenario, my lord, the first one is the owner of the vehicle is in possession of the contraband. Secondly, my lord, contraband recovered from the possession of the driver or agent. Thirdly, if it is a stolen vehicle. And fourthly, recovered from third-party passenger. So in the instant case, the case in hand, my lord, here the contraband was carried in a Tata vehicle, Yodha,
Hmm.
and there are 2 persons. And the police intercepted the vehicle and seized the contraband from 2 persons.
Hmm.
And my role was, so far the charge sheet is concerned, my lord, it says that, my lord, I was driving a Maruti Suzuki car and I am escorting them.
You own both the Suzuki car and the Yodha, no?
No,
You are only with the Maruti car.
Maruti car. Two cars escorted them. One is, my lord, Creta, and that Creta has been given
In Jimma.
Jimma. As because I have been charge sheeted in this case.
Hmm.
so
That is where this part comes in.
Yes, madam.
That is what we are trying to see.
Yes, madam. So far,
This,
Vishnu,
where no allegation has been made in the charge sheet against the owner or his agent.
yes, madam.
है ना?
Yes, madam. But if we go to the Vishnu, this case, my lord, paragraph 38, my lord. Lordship have the Vishnu, this case, my lord.
Mhm. No, we don't have the Biswajit this case. What is the relevant part you are trying?
Relevant part, my lord. Just
29 and 30?
last 38, my lord.
30?
38, my lord. It doesn't say anything, my lord. My lord, only the thing is that, my lord, the car will be kept in an open place, my lord.
But you are one of the accused.
Yes, one of them.
The
Lordship,
we are of the prima facie view that 1 and 2 would apply. I'm sorry, I think 3 and 4. The one
Three and four, my lord.
3 and 4.
3 and 4, and to an extent 2 also. But Denas shade, my lord, in the Denas case, my lord, it is 2, my lord.
It was not, this vehicle was being used as a decoy or as an escort.
But this case, last paragraph 38, my lord,
Hmm.
it says, my lord, as the car will be kept in an open place, subject to, my lord, rain and.
Now, if that consideration is taken into account for every case,
My lord.
then it will lead to a situation that every car has to be given away.
Yes.
That
what
cannot
I-
be the intent. The intent has to be that you don't need the vehicle any further. It is not involved in the trafficking. It may not be involved in the trafficking. At the end of the day, you would not have any use for or confiscating. You cannot confiscate the vehicle itself
Yes.
because it was not used. So allowing the value to diminish at this stage is not required. You release it. But in this particular case, this vehicle is being to escort the other vehicle. Now, people know it to be an escort in the trade. Let us assume it in that way.
Yes.
Once this car is allowed to be used again as an escort, it helps the trade. So it may require a confiscation. End of the day.
But Vishwanath, my lord, the last 38, it doesn't say anything, my lord. And because of the this 4 scenario, I am not on the. I do not lie.
No, you are there because you are an accused. And
As
none
an
of these apply. None of these would, in so many words, apply. But the apex court has also said that you apply it on a case-to-case basis. In this case, we find that it's an escorting vehicle.
It's
A vehicle used for identifying or a
Fine.
vehicle used to
But the other,
decoy, escort, whatever you call it.
but the other car, my lord, the Creta has been given Jimma, my lord.
You have the order.
No, but that order I have not, and I have gone to the.
Is it so? The other vehicle has been given on Zima.
Yes, my lord.
Huh?
If required, my lord, then I'll produce that
We
order.
can have it on the 5th, but prima facie, what was the allegation against that Creta?
My lord, that order is not available.
No, no, here we may have something in that lower court, trial court order. Creta has been given because the owner is not an accused.
Yes, that's true, my lord.
So therefore, this other case, he fell in one of the categories.
Otherwise, we are on the same footing.
No, otherwise you are not, because you are the owner of this vehicle
My
and you
lord,
are an accused.
Assuming but not admitting, if those 2 cars are, my lord, escorting, we'll be on the same footing.
But through whom was it being escorted? When the police say that the owner was not there escorting it, therefore it has been given to the owner because the owner is not an accused. Here the Swift Desire owner is an accused. That will change the whole scenario.
That's true, my lord.
So earlier occasion, Learned APP Bhaskar Sharma is gone for TCR and make submission regarding the on the basis of the base.
At this stage, I don't think on the legal submissions we are not. Otherwise, but you have to tell us why you need that car to be with you all the time.
Yes.
That part we have not seen. That we may not release it is what we have understood from Mr. Sharma. Since Mr. Sharma has sought an accommodation in the second half, we will not pressurize him today, but let us have it on the 2nd or the 5th. Only on the issue why you need to retain it, nothing else. We are convinced that we may not release it, but you have to convince us that we should not release it. Huh? So that the discretion part is gone on your submission. Otherwise, keeping the vehicle there only because the owner is an accused, where the vehicle, nothing has been found inside the vehicle.
Creta was granted Jimba because he is not the accused owner.
And in this case also, the Suzuki does not have anything found inside it.
But the vehicle is escorting that vehicle.
The Creta one to escort police.
So you have to tell us why you need further custody of it when the owner is himself an accused, but the vehicle is not being used for the transactions.
And fifth, Lordship.
Otherwise, every vehicle of a known NDPS person has to be confiscated. Can't allow.
Not on 5 or 6, no, can you on 9th, my lord?
9th, on the 9th of March. List again on the 9th of March to allow Mr. B. Sharma, the learned APP, to answer the queries of the court as to why further custody of the vehicle, Suzuki, Maruti Suzuki vehicle is required when the other vehicle has been granted Zimma, and there is no allegation that this particular vehicle of which the Zimma is now sought was involved in the trafficking of contraband substances. Yes.
Handling item number 35.
I'm obliged.
Yeah. Mr. Gugoi, awkward position for us having you here in a criminal matter.
No, my lord, in fact, my lord, so far as this informant is concerned, my lord, there is a PIL pending before the division bench against the anti-quack quack doctors. During the pendency of the PIL, he has been now appointed by the Assam Council of Registration, Medical Registration, as the main officer for that unit, my lord. On that capacity, perhaps this FIR has been lost.
Now,
And we have
issue
been
is
submitting
this.
reports from
No,
time to time.
issue is this. We remember a particular matter and we remember you being associated with it in some manner. Mr. Choli, I don't know. Where there are three forms of medicines. Alternative medicines, the regular allopathic where you get the MBBS degree, and there is one more form. There are three forms. Now, there was a school teacher or something who had done this course. He had a big clinic, was one of the most prolific doctors known in the area. Someone lodged a complaint. He lost his job. In fact, in an accident, I think he lost his children and wife also. Then he came to this High Court in a writ petition. Statement was made that he is not registered with the Medical Council, Assam Medical Council, because he has not done it. He has not done the MBBS.
Yeah,
But the other courses of medicine which are recognized, this alternative, Unani or homeopathic or Ayurvedic, these are not required to be registered under the AMC.
They will have their own manual councilman.
Something
will have to be
Then we had tried to find out whether that particular person was registered under his own council or not.
Right.
They traced it out. They found that yes, he was a student and he had passed out. But because they don't have a system of recording that,
Yes, yes. That is
therefore they are not keeping a record. Therefore, their roll numbers or something they put up as a registration number and they continue the practice. So that Miss Borua was there. Correct. Miss Borua was there. If that is so, this man is running for his life because he is an alternative medicine doctor.
But my lord, he is a teacher also. Now.
Yes, he can be. He can be. There is no difficulty. If he has got a graduation, then he does that Unani part or whatever part, if it is allowed in law.
He will go for that practice.
Then he goes for DLED. Then he applies for a teacher's job. He joins as a teacher.
The allegation
Where is
that
the bar?
practicing now. Practicing now.
No, I was told that he has got a job recently. He has been appointed.
Lots of you see, I have checked it, he states that he was at page 27. This is the order of 2017 of the bail petition. AB number 2941 of 2025.
2941. Yes, what does it say?
Page 27. Assam Sarva Shiksha Abhiyan, they engaged him in sometimes with 8/9/2017. Then thereafter, regularized on 2nd of September 2014. So from 17,
he should not have worked.
Should not have worked.
He should not have worked. That is fine. He will lose his license.
Yes, regarding
He needs
whether
to
he
be
can practice
arrested.
or not.
Does he need to be arrested?
No. Here, my lord, entire issue is regarding his practice. Say that, my lord, he is a quack doctor. That's the
Quack, whether it can be called a quack or not.
What we will take away two at least. May I have some information from the authorities on this point? Because yes, my lord, annexed one document. There is, my lord, the Council of Alternative System of Medicine, West Bengal. He says, my lord, he is registered there from 1998. Page 26. 26, my lord. Probably, my lord, this is the registration number he has mentioned in his prescriptions. Page, my lord, 26.
I was at page 19 of the same file.
My lord. This is the FIR.
Because in that case, a statement was, I remember that statement, that he is not required to be registered under this because he has not qualified that degree.
My lord.
But alternative medicine is recognized. And it was a very similar FIR. He was placed on, yes, he was placed under suspension. Then the entire criminal process was going on. After his retirement, he came back looking for his pension.
Acha.
Then when the things were started to find, we started digging, the department found this. Miss Burwa should remember.
My lord.
He is on interim. We are not.
Not here.
Then there's another thing. We gave him an interim in one of the cases.
Oh.
Exactly same facts.
Hello.
A 0 FIR is now initiated against him.
Your Lordship, one thing I want to clarify, Lordship. I have found that, Lordship, the two FIRs are there, but it has been amalgamated, Lordship.
So if he's
It has
on
been
bail on one,
amalgamated. It has
if
been
he has got the
amalgamated,
anticipatory bail on one, it
Lordship.
will work for both.
But another thing is that, Lordship,
Hmm.
I have found another thing. The IO has prepared for requisition for a verification of admission and certificate that he has given
Huh.
to one Rajiv Gandhi Open University from which he has Lordship passed out.
Medicine from Open University.
Lordship.
Oh, this is raising doubts.
Lordship,
Something
this
is
is
there.
the
And the entire issue is
Lordship.
regarding the practice.
He could have done it from WhatsApp University. Huh?
It is because of that, Lordship. Rajiv Gandhi Open Institute is there.
So we'll do one thing. We'll let you have your this thing done. We'll record your statement that the two FIRs have been amalgamated.
2026 it was given.
We will record your statement that the two FIRs have been amalgamated into one. He is already on enjoying the privilege of pre-arrest bail. Therefore, we listed sometime in March last week. Have your instructions by them if it is WhatsApp University or AR University. What do you call it?
Then it will be clear.
Wireless Communication University. We'll see what is to be done.
That will be clarified. That will then the clarification will be
Take
made.
this down in both the ABs. AB to AB number Iman, AB number 3059. Huh? The petitioner had been granted the privilege of pre-arrest bail in the interim by order dated 16/12/2025 in AB number 2941 of 2025. Today, the Learned Council Learned APP has submitted that both the cases, both the FIRs have been amalgamated into one. Therefore, the grant of privilege of pre-arrest bail in AB number 2941 of 2025 also suffices the purposes of AB number 3059 of 2025. Yes?
Amalgamated to 1170, Lordship. Silchar PS case.
Amalgamated into PS case number?
1170/25.
Silchar PS case number, huh? Well, therefore, the pre-arrest bail granted in either would suffice the cause of both the ABs. Full stop. The Learned APP has submitted that the verification of the documents of the petitioner have been initiated by the investigating authorities. Full stop. He therefore pays for some time to place a report before this court. Accordingly, lists this matter on the 30th of March, allowing the APP to have the report. Full stop. List again in the interim. The interim protection granted earlier continues. Huh? You get the documents. How do you do by distance medicine? Ask your client.
Okay, what date is fixed, Lord?
30 of March.
Lord, much obliged.
Admission item number 13.
Question I'm with apology, Lordship. I pray to accommodation for today, Your Lordship.
Item number?
13, Your Lordship.
13.
So here will I am appearing on behalf of senior counsel Mr. PKTY.
Huh.
That is that NHPC method.
NHPC.
NHPC.
Oh, that one, that promotion.
I'm not much acquainted with the case. Lordship.
Promotion.
Yes.
Yes, can.
He does not want the promotion. We'll have it in August or September. He's saying so. I don't know.
but I have been told that.
Today was fixed for reply argument actually.
For your reply when?
Worship on 12th.
Some file to
12th of
the
March.
Can it be on 12th, my lord?
Read into lordship.
Huh?
No, my lord.
Ish. When do you want it? 12th of March?
My lord. It's a hearing day.
The request made by the learned counsel for the parties lists this matter again on the 12th of March. For reply by the learned senior counsel for the petitioner.
Highly obliged, my lord.
Much obliged, Lord.
Item 14.
My lord, in this case, I am for the respondent number 1 and 2. I pray that the petitioner may be directed to provide me with the copies of the criminal petition.
Why have you not provided, madam?
Lordship will provide it by today,
Huh?
Your Lordship.
You don't want him to contest?
Yes, Your Lordship.
Yes.
The learned counsel for the petitioner, Miss,
Each Bursha.
has undertaken to provide extra copies of the criminal petition to Mr.
Dinan.
Learned counsel appearing for the respondents. Full stop.
Lordship.
List this matter again on
Let it be at the.
your convenience, sir. Since you are to take the copies, yes.
If they provide us with the copy so that we can file our affidavit addition, this thing, affidavit in opposition. Let it be in the month of. 12th of
Eh?
March, 12th March.
12 March, you'll be able to file your reply by that time.
Or let it be 19th, my lord.
19th of March, 2026.
That's,
By which time the respondents would be at liberty to file their objections and stuff. Interim order passed earlier.
Sorry for the inconvenience, Your Lordship. In regard to item 44, when the matter was called due to the oversight from my side, Your Lordship, when the matter was called, missed the item, Your Lordship. The petitioner appearance has been recorded, non-appearance, Your Lordship.
Huh?
The petitioner since couldn't appear when the matter was called, it has been recorded as non-appearance, Your Lordship.
Huh?
So Your Lordship may kindly record as.
When none appears, we'll have to write none appears. Yes, order to 44th side. Wait for some time. Let us find out if I have signed it already. 44 has not been called till now.
Has been. From the orders column, Your Lordship.
44 আপনার কইছে নাকি? কোনে লিখছে? কি লিখিছে সব? multi copy.
Issue reminder. Please take it on 30th of March 2026. None appears for the petitioner. There is an interim order keeping further proceeding in GR December very soon, pending in the court of the Gauhati JMFC, County Gauhati, in suspension. If on the next step there is none to represent the petitioner, this court may take such absence to be withdrawn, and the interim orders passed may be modified.
We have not done anything today. We have just recorded non-present. The date when? I remember signing that order. I have signed the order. I cannot change it now. Eta কাম কৰিব টাটল এটা মাৰি দিব After I have signed the order. Now let's see if you can do something. But no damage has been done today. Be present on the next day.
Surely on the next day we will be present. On the next day we will be present.
Be present.
Obliged.
Yes, madam.
Lordship is taking mentions, madam.
Huh?
Lordship is taking mentions, madam.
No. Which mention? Huh? নহয় এটা যে মেনশ্যন কৰাৰ কথা আছিলে হেৰি কাৰণে আইখন ফাইল কৰি নাই
Last topic, we have completed our argument actually. And
he is also not there.
he is there.
I saw him going out.
He's not in a mood, he always tries to avoid it. That's the thing, let my submission be recorded.
Today I am not in a position to do much in a matter. We had heard the matter at length. What was the matter about?
Your lordship have heard both sides. On no work, no pay. Page 98. That is a order we have challenged.
Page 98.
98. Paragraph 14. Now therefore taking a holistic view of the expression submitted by the applicant in respect of instant case of controversy from leave and the reason thereof, the understanding is compliance order passed by the Honorable High Court of Gauhati and statutory provisions vested under 1303 take a sympathetic and lenient view of the circumstances of this case. Have a status of the order of dismissal passed by the commandant to the restate him in service. However, since any punishment for the unauthorized without leave can be awarded only after trial or observing a laid down proceeding in commandant 15 battalion, Kajolgaon, being the disciplinary control authority is at liberty to take appropriate disciplinary administrative action against the individual as deemed fit, in according with the provision contained SSB and rules. The period between date of dismissal from service and date of assumption of duty, subsequent to the other regularized on the basis of principle no work, no pay. And as per this. So this I have challenged. Subsequently, after that, my lord, that page 104, the commandant passed another order. Stating that the unauthorized absent that 11/12/2019 will be regularized and dies none for the purpose of pension benefit as per extant rules.
You are required to give a representation on the punishment. What is the punishment?
Punishment is
Where is your representation?
no, I have challenged that no work, no pay, my lord.
You don't want any. You have challenged only the no work, no pay part,
Yes, the no work, no pay part.
not the other orders.
Not the other, I have not challenged. that.
Dias non is not challenged.
Not challenged.
Why do you challenge the no work, no pay?
Because he is willing to join, but he was forced to, he was
From
compulsory.
the date of termination
Date of termination.
to the date of reinstatement,
Yes, yes.
they are treating it as what? No work, no pay.
Okay.
And what about the dias non period? Which period has been taken to be dias non?
Yes, then from the date of from unauthorized leave to the date of the dismissal.
When was your date of?
Date of 11 unauthorized leave from 11/2/2019.
To
16/6/2019.
19. Dias non,
That's done.
not challenged.
No, sorry.
And this no work, no pay is from the period from?
No work, you know, pay from date of termination till the date of reinstatement. That is from date of 17/6/2019 to 31/1/24.
Okay.
Yeah, Marshall lost your stuff.
Very serious apprehensions, Mr. He says that you are not trying to attend the matter.
In the morning hour also.
I would actually ask you to refrain from making such. Doesn't look good.
We can do it some other day also.
No, not on that. saying that he is usually not here. We had a long association with him when we were there. And seldom have I seen him shy away from a matter. One of the best known rivals, fighting to the last. Where is that period of no work, no pay? Which is that period?
Which is period is no work, no pay from 11,
What is the date of dismissal?
76, 2019.
17
6, 2019.
Till
Till 31, 1, 2024.
31/1?
2024.
Okay. So you say that the no work, no pay is wrong because you have been reinstated.
Reinstable and that day, actually that period.
Why was that order set aside? What happened to that order of dismissal?
Yes, what order of dismissal?
What happened to that order of dismissal?
The order of dismissal. Will go. 64.
64.
Huh?
Page 64.
64 page. That is a type copy. Original copy is 68.
Yes, then what happened?
Thereafter he filed an appeal.
Yeah.
An appeal was rejected.
Where is that appeal?
Appeal on page.
No, the appeal.
Page 74.
Appeal is after the.
After the dismissal.
Oh.
Because he came to know when he wants to join, he after that, when he write that.
Okay, you have written many a thing, okay.
When he he seeks a desire to join.
Where?
Para, I've stated in para, my lord. Page 7, my lord. 7, no, page 70 now.
Okay, 74 read. Then?
Yeah,
Then what happened?
then we came to the High Court.
No, then there was an order.
Order. High Court has passed.
18/11/2019 is an order passed in appeal.
Yes, yes.
What did the order say?
Upheld my termination.
Okay.
Without proper reasoning. Can we come to the High Court in page 89-90? Relevant part is page 90. 93.
91.
No.
Paragraph 13.
13. What a
P0. Paragraph
13.
1-3.
1-3 page 93.
93.
Just a minute.
No, that is the operative portion. Facts from para 9. If you'll also go through, you'll also note the facts based from para 9. You'll also go through from the para 9.
Then what happened?
Then High Court said that the operative part, High Court said you consider, and accordingly, on the basis of High Court order that I have stated in para 10, page 13, that the petition begs to submit thereafter in compliance with the Honorable High Court order, the appellant authority, that is the respondent number 4, has passed a fresh order while bearing number so and so, thereby setting aside the dismissal order dated so passed by the respondent number, accordingly resisted the petitioner.
What happened to the punishment that was proposed to be imposed upon you?
That is the dice now.
No, no, diasnon is not the punishment. of-
Punishment, no work, no pay. But
What is the penalty?
penalty?
Sir, we will again try to understand. Now, therefore, keeping in view page 104.
No, penalty. The state way I will dismiss actually.
Eh?
State way I will dismiss most of it. The other committed service.
Page 104, Mr. Goswami.
Hello.
Kindly have page 104.
Hello.
And where is the second paragraph do you find?
Consider.
And whereas the, after careful consideration.
Para 2. Hmm.
Second paragraph. The case and the direction of the so and so Bamanga is under sign is provisionally come to a conclusion that so and so committed an offense under section 21 of SSB 2007 and the gravity of offense is such as to warrant the imposition of disciplinary action accordingly proposed to conduct a summary disposal
Hmm.
as per SSB 2007.
Now, this summary disposal. Did summary disposal found him guilty or not guilty?
That is not.
You could not answer that when we were asking you. Now we are interacting with him. Allow us.
No.
Hmm? So now there were two proposals given. One,
No.
that I want to summarily dispose of the proceeding.
No.
I'll go for a summary proceeding. And the period when of your unauthorized absence, in either of the two cases, whether you are guilty or not, I will treat as diasnon. Is it not?
No.
So 7 days, he was given to reply to it. He does not reply to it. And therefore, the order on the next page, the formal order, that it will be regularized for all aspects as diasnon for all aspects. Is it not?
No.
Hmm? And interruption of service will be condoned and it will be treated as pre-qualifying service.
No.
Is it not? So now he does not lose in his pension. But there might have been another punishment on him because of this summary disposal. Law says that in case of unauthorized absence, the court has to leave it to the disciplinary authority to find out how to treat the period between the deemed from the date he was terminated last
No.
and the date he was reinstated. If he is found guilty after giving him all the chances, then you have the authority to treat it as you want to.
No.
But if he is not found guilty, then FR 53 or 54, all those things come in. If he is found not guilty upon reinstatement, then he is entitled to everything. Coupled with Dipali Kundu Survase, which will tell that he has to make that prayer in the writ petition or in the appeal place before you that he is going hungry and does not have any other source of income.
No.
And that he requires the money for that period. If that is not given, that he is not given, then he now cannot come and say that I need all the salary and allowance. Is it not?
No.
But you have no finding of guilt here. So will fundamental rules apply to give him all the benefit? Diasnon is not challenging
No.
the period of his absence. He is required to be given a notice. He was given a notice. He did not reply to it. Period of absence, illegal absence as diasnon. Is it not? The order of termination was set aside on. When did you approach?
24.
Where is that order of termination?
Yes.
17/6/2017.
76.
And when did you apply?
Date of dismissal.
Date of dismissal?
Page 68.
He approaches in 2021. The appellate order is of
2019.
2019. 2 years later, he approaches, is it not? Or at least 1.5 years, since it was end of 2019. Huh? This court says that the appellate authority should have taken better care of it.
Accordingly, appellate authority passed this order.
Then the appellate authority passed the order that the dismissal is wrong. Why is it wrong? Because it could have been done after a summary court procedure, or maybe any court martial or anything. What do they call it? GSFC or what? After taking a disciplinary proceeding as per the SSB Act and rules. So the first initial dismissal was wrong in law.
No.
Because it was not after a procedure laid down in law, is it not? Now, when the dismissal was utterly wrong, because the law was not followed, you kept him out of service by an illegal order. In your final orders, you do not have any finding of guilt.
No.
Then you are simply treating it as diagonal, and he is not objecting it to you. And how can you deny him the salary for the period of term, from the date of termination to date of reinstatement? He remained illegally terminated. Have you seen that page 98? Para 15?
No.
However, any punishment for answer without leave can be awarded only after trial or observing laid down procedure. He is at liberty to take appropriate action, is it not?
No.
So that means that he did not take the appropriate action of a trial or the laid down procedure.
The commandant is directed.
So therefore, now if the commandant did not follow the procedure, the termination becomes illegal. Not because of principles of natural justice or anything, but because the procedure is not allowed.
No.
Illegal termination. Pay and allowances for the period of termination is the law as we understand it.
No.
Since it is punishment or
Because again, you will see the commandant while passing the order does not say he is found guilty of being unauthorized absence. He says whatever has been done. I will treat the period of absence as diagonal. He does not say that you are found guilty.
No.
Once he does not say, then what happens? Not guilty. That is the Indian law. Innocent till pronounced guilty.
No.
He is not pronounced guilty. What do we do then? Have you gone through the Dipali judgment? Dipali Survase. There is a judgment, Dipali Survase.
people could do so.
There are some conditions laid down.
Yes.
Para 36 or 37
Yes.
towards the end.
Yeah.
Can you see? What is that? Just before.
Para 38 from para 31 onwards.
Possibly, I don't know. 1, 2, 3, 4, 5, 6. There have been several conditions.
Yes, yes. 2013 10 SCC 324.
Para 38.
38.
In cases of wrongful termination.
356.
Cases of wrongful termination.
Reinstated with continuous service and back pay is the normal rule.
Normal rule. Aforesaid is subject to rider.
While deciding the issue of back pay,
Length of service, nature of misconduct,
yes.
if any, found proved against the employee or the workman.
Yes.
So the nature of the misconduct found proved. Your commandant does not say it is found proved. What to do? Ordinarily, who is desirous of getting back wages is required to plead at least make a statement that he was not gainfully employed. Now, this is where we can look into the writ petition. Have you made a statement?
Yes, yes, I made it.
That I was not gainfully,
Yes.
where?
Page 17. Page 17. That's
1-7.
Yes, 1-7. 15 from the top 15 line.
Huh?
If from the top 15 lines, 17, page 17,
Hmm.
15 lines from the top. It is also aforesaid mentioned here that the period from 10/1/2019 to 31/1/24, the petitioner not gainfully employed for profit at any place whatsoever.
So that condition is fulfilled. If the employer wants to avoid payment of full back wages, then it has to plead and lead cogent evidence. Thirty-eight point five. Do you have this judgment with you, sir?
Malat, I have
Huh?
gone through it, Malat.
38.5. In cases where the competent court or tribunal finds the employer has acted in gross violation, it will be justified in directing full back wages.
I have underlined.
And this no work, no pay, as given in JK synthetics has been held to be bad law. Where is the JK synthetics part? It was somewhere in paragraph 20. Hindustan Tin. Prior to that. Para 37.
30.
At page 356 itself, para 20 and 21, just above that. In italics, plus item D and E. Your commandant does not hold him guilty.
Malat.
Have you filed your affidavit?
Affidavit doesn't file now.
What is the stand? How do you contest it?
There are 18 page 207 regarding the counter to the paragraph 16 of the 17 of the petition.
Paragraph 18.
Mala 18. 207 page.
Huh?
Page 207. The affidavit
Something is wrong with your this thing.
got it.
The read petitions ends at 104 or 105, and the affidavit starts at page 246.
246 Mala.
Huh.
270 Mala.
Okay.
Paragraph 18 is there Mala. It is counter to paragraph 16.
That is at page 265. Yes. That with regard to the paragraph 12.
Judgment order is so and so. Wherein held at for the revision mentioned herein above, the above,
Huh?
the order dated.
Just a minute. We are on different pages.
It is a reply to paragraph 16 and 17 to the writ petition.
Just a minute. Kindly come to page 265.
270.
Page 265. This is paragraph 18.
Malad, sorry, Malad, some.
Then you have
It
again
is
at page
my
20.
Malad, fault, Malad. Again,
Page 270.
you also can you look into page 272? Again, the same paragraph is repeated, Malad, sorry. You also got in Malad.
Yes, you're reading it. Now this
Yes,
at
what is
page
it?
272.
Malad.
This page 272.
Malad.
The petitioner is guilty for unauthorized and willful absence. You never held that procedure. Commandant was required to hold it.
No.
Summary procedure.
Malad.
What happened in that summary procedure? Huh? What happened to that summary procedure? No, not properly. Your department does not want to defend it properly. From 26/12/2023, they have gone to 5/2/2024. What happened to that inquiry? Nothing given before this court. Unless he is held guilty, can you say? This affidavit opposition is very beautifully drafted. Unauthorized absence, why it is unauthorized absence, how there is a difficulty in running the force. So beautifully done. One go, one join. It is a border force. He cannot enjoy luxury to remain overstay of leave. Where is that in the commandant's order? Yes, should we close it?
Malad.
Hmm?
Malad, in view of this, Malad, finding.
Area and salary 7 except what he would, the allowances that he would be entitled to on actual discharge of duty. That allowances he might be not entitled to, but otherwise salary and all, how can you stop it? When you have not found him guilty, that is the only position. All the affidavits, all the Humpty Dumpty will not save. If you want to give your written arguments, we will fix a date for your written arguments. And on that day, we can dispose it of. I am not in a form to dictate a full order today.
Malad.
So either I have to keep it CAV or allow you to give your written arguments.
Malad, ask your losses, please, Malad.
Say,
My lordship is there. Your lordship is there.
we'll do one thing. We'll.
Well, I have nothing to give written argument. My stand is clear. If they want to give.
Do you like to, or should we keep it as
On
CAV?
basis of the affidavit, this is our stand, Malad, your losses.
No, the problem is if I go through affidavit, I will have 2 paragraph 18.
Malad.
I will have 2 paragraph 18 by your affidavit. There are 2 paragraph 18. Which one do I choose?
My lord, sorry, Malad.
Matter, arguments heard and concluded. Judgment reserved. Parties may submit their written arguments if they so desire on or before the 6th of March.
Highly applied.
Judgment reserved. Huh?
I think item number 24.
Yes, sir.
Lordship, in this case, none appears on behalf of TTRI.
TRI.
Date may be, Lordship.
You are saying that 47 and 48 not given to you in a language that you understand.
Lordship.
What language do you understand?
But Lordship, no copy was served
On?
to the accused person as well as his family member.
No
No,
47, 48
Yes,
served.
nothing.
But Mr. Presumed learned counsel appearing for the petitioners. One or two matters? One matter?
Two.
Two matter for the petitioners. The matter was called up in the first half of the day. None appeared for the DRI. Matter has been called up again on the second half. None appears for the DRI. Scan copy to আহিছে নেকি sir? Mr. Goswami, can you act as a amicus for the time being? I don't like to go through all this record. Kindly find out if there is a 47, 48 here. Huh? It's a DRI matter, but case diary you can go through. You are an APP, very certificate. Let have deduction after some time. Video 47, 48. He's only this thing is 47, 48 not served at all. Record to.
I mean, I can tell.
Maybe the lordship. Here, my lord, the issue of maintainability has been raised, my lord. Because apparently the girl. is less
On
than-
what ground?
It is not maintainable, lord.
Because she is less than
Because
16 years.
65(1) is there,
Oh, yes.
482, 4 is there, lord. And I have citation also, lord.
It's Nazir Hussain.
Nazir.
Like to go through it?
Yes, yes, lord. What has happened, my lord, when prima facie offense has been made out, it is not maintainable, my lord. Because in the SC/ST Act also Supreme Court has said that AB is not maintainable in the SC/ST Act. my lord. Honorable Supreme Court has said that if prima facie offense is not made out, then it is maintainable, my lord.
Okay.
My lord, here the boy is around 18 years of age, my lord. The boy before your lordship, my lord. The boy before your lordship, the petitioner, my lord. He's on 18 years, 8 months or something like that, my lord. Right now, my lord. Not 18 years, 8 months, my lord.
He was not 18 years.
No, no, he is. He is now 18 years, 9 months, 23 days. my lord.
When did the offense took place?
As per the FIR, my lord, the offense took place 10 months ago. So at that point of time, I was 8 or 9 days shy of my 18. my lord. This is a consensual, no, I would say consensual, my lord, because the allegation is against me. But adolescent relationship, my lord, not of that sort that I am a school teacher or I'm a predator. I'm not saying that, my lord, but it's not that, my lord. And lordship knows, my lord, that new, my lord, that Romeo Juliet clause that has been suggested by the Honorable Supreme Court to the center, my lord.
We only hope they don't end up in the Romeo Juliet fate, no? We can wish them better.
That is there, not that, my lord, but
Hmm.
on maintainability, my lord, that SC/ST Act, that, my lord, I could not find immediately, my lord. The lordship wants to place that, my lord, but need some time, my lord.
But as it is 65(1), lordship, it is clarified.
Yes, yes, my
The
lord.
citation is also there and act in the act also. This
I'm not
clearly-
saying it's not that in the act. It is in the act, my lord.
Now, this is what we don't appreciate.
Which
Have page 19.
19, my lord. My lord.
Now, we will reject your case only on this ground. Sought to mislead the court. Page 19,
Which part, my lord?
that is the SME's FIR.
Yes, yes, there is some typographical error.
Now, you
There's
tell
some-
us that the word consensual appears anywhere in that FIR. You are going for all sorts of.
I'm not saying in the FIR it is that consensual, my lord. I'm not saying that.
Oh, it is there. In the type copy, it is there, sir. And that is the word which when heard 18 years old, 19 years old, 17 years old, consensual, all that we tend to think in a positive line. But when the FIR does not give any inkling of consensus,
No.
who inserted that word?
Consent.
Shall I read out the word consensual to you? Let us say, in such a way the accused has been committing sexual intercourse so and so. I read that word, consensus.
Committing sexual intercourse with her since long. Now as the
Consensus we read. Or did we miss the word? Or we read it?
consent, my lord. There is some niece. It should have been niece. It is nephew. It should have been niece. It is nephew. I know that, my lord.
That is another thing.
Consent, my lord. That I could not.
Oh, consent, no, then it is my mistake. Sorry. Where did I read? I read that word consensual.
I said that, my lord.
No, I read it.
Oh, in the petition it is there, my lord.
We run through, but we remember that
It is in the
word.
petition, my lord.
It is there in the petition,
Yes, my lord.
not in the translation.
Page 6, para 8, my lord.
Okay.
And page 7, para 9, my lord. That was our, my lord, defense, my lord.
No, my.
I beg my lord's pardon, my lord. I did not mean that, my lord. I beg my lord's pardon. Enticing her, started relationship after came into love relationship, the accused person committed sexual intercourse with my, it should be niece, my lord, it is nephew, against her will by alluring her in a different manner. That is the allegation, my lord.
Now our hearing and these two must have collided. Our apologies. Fine.
I beg my lord's pardon, my lord. I error, my lord. Page.
Yes, where is that content of
It is in 480.
prima facie?
Lordship.
He's saying a prima facie case has to be made up.
That has to be placed before. In the scheduled caste and scheduled tribes, Lordship, it is it is there. Prima facie. But in this popular cases, I have not found, Lordship. No, it is not that the prima facie, it has to be established first. It is nowhere. But in the BR Act, it is clearly stating that, Lordship, these two sections, 65 and 70, subsection 2, 482, subsection 4, Lordship. It is clearly stating the things, Lordship. It is barred.
No, we have rejected one on that ground.
No, I have also, Lordship, in earlier cases, I have also rejected on this ground. I have raised this point, Lordship, that it has been rejected. It is there in a statute, my lord. I'm not saying it is not there, my lord. But in a similar situation, no, it is not there in the SCSC Act also that prima facie case was made. No. Whether there is any Supreme Court citation? Yes, that is what I'm submitting, my lord. One Supreme Court is there, my lord.
When would you like to have it?
Can it be a Monday, my lord?
Yeah, yes.
Monday, my lord.
At the request of Mr.
Beg my lord's pardon, my lord. Another typographical error is there, my lord. Page 21.
Minor typographical errors or this thing
The date is wrong, my lord. It should have been 2007, 2009, my lord. My date of birth, my lord.
No, I caught you off guard when that mistake was not there.
It may be in another case, Lord. It may be in another case.
No, it is because I have been advised not to take up medically. Trying to get the matters done. List again on Monday. The request of Mr. N. Mahajan, learned counsel appearing for the petition.
Highly better.
Yes, sir.
Particular Lordship, we have sent our to a concerned police station yesterday also. So the fixed date, Lordship, another date, we will take instruction whether service is completed or not. From our office, it was sent yesterday also.
Okay. When is the order of?
31/26, madam.
Huh?
Order of 30, I think.
2016.
The case of 2016.
My
lord, service was not completed. I have taken.
No. He's behind bars from 2016.
No, he's on bail, man.
He's on bail. Or then there is no such hurry in the matter, is it not? The learned APP has sought for a small accommodation to verify the service of notice on the respondent number 2. List again on?
I need for lordship's continue.
Yeah. 27th of March. Mr. So-and-so, SK Talabhe appears for the petition, appellant.
Petition item 50.
Lordship has already heard this matter, Your Lordship. Your Lordship, that ACPS and MSCP, Your Lordship. Lordship. Your Lordship wanted me to have one judgment whether Your Lordship, after such long time, Your Lordship, refixation can be done. Lordship, I have prepared a short note on submission, Your Lordship may go through, since argument has already been completed. Your Lordship may kindly come to one judgment, Your Lordship, that is last but one judgment is that advance, Your Lordship. 2024 SCC online SC 1909. This is the issue is on refixation of pay after retirement and refixation of pension also. After going through, Your Lordship, facts are slightly different. Your Lordship may kindly come to
21.
Para 26, Your Lordship.
Para 21 is there.
21 is also the 26, Your Lordship may kindly say. The learned single judge as well as the division bench of the High Court of Patna also seems to have fallen in the same error. Then, in addition thereto, we are of the view that any step of reduction in the pay scale and recovery from a government employee would tantamount to a punitive action because the same has drastic civil
Yes.
and civil
It will
consequences.
be on Monday, Malad. Suppose my part is concerned, why I'm saying is, Malad, unlisted matter is pending. Time being motion is pending in court number 6.
All
On that
sudden.
Monday, Malad, I've got the judgments of this honorable court, Malad.
No, he is referring to, let us not take you on this thing. He is referring to Jagdish Prasad Singh, 2024 Supreme Court judgment to say, at this stage, it will not change for the petitioners. You may be entirely correct in what you are doing, but at this stage, doing it for the petitioners would be. Now, we'll keep this as CAV. We'll keep this as CAV. If you find anything does not match with it, you have the liberty to file a written argument contradicting what is there in the judgment, that
No, I will
actually
give
they are
the-
not,
Just, Malad, I will give the printouts of some judgment, Malad.
whatever.
They are
Give
giving
us the
everything
relevant paragraph number.
Otherwise, Malad, facts are clear. Well, recovery part, Malad, of course, there are lots of judgment, Malad.
The recovery is totally not done.
Yeah.
The judgment that he has given us, only 2 lines we have seen. We have not read the whole of it, but 2 lines. At this stage, the correction in the pay after the retirement would not be justifiable. That is all. For these persons who are before us in the court,
But Malad, there, Malad, Katina doesn't.
which says that it can be done, yes.
There, Malad, in case of teachers, Lordship is, Malad, aware of.
Yes.
They enjoy everything now at the time of pension, it comes to light. They are
We have,
protected
this
But
court
there
has
is an
allowed.
order, Malad, of the honorable court always that, Malad, it should be given in the correct.
Correct.
Ultimately, public money.
But that was this is a 2024 judgment of the Supreme Court. Those cases, if we remember correctly, prior to that, we have convinced the courts. 2024, if the apex court is convinced otherwise, our hands would be tied. Only that. Otherwise, prior to that, Galore, Rafiq Masi says so. Don't recover. They stop at don't recover.
That part, yes, recover.
Don't recover. But correction, no one had stalled it. In fact, there are judgments
Yes.
from 1960s, is it not?
Yes, Malad.
Saying that correction of an error by the government agency is permissible at any time. At any time it is permissible. There is no, but in this particular case, once they have retired and people ahead of them and behind them are both enjoying it, will it be justifiable?
On, Malad, that is the differentiating factor. Otherwise, Malad, yes, being there.
Everybody
they are
prior to
class
them?
within themselves, Malad.
Those who are now in job, enjoying it, those who.
1994 to SCC, I have found, Malad, one more judgment that it can be recovered.
Yes.
It can be recovered.
Yes, but here the mitigating circumstances are different, will not hold you back for long. We are also having a little, you go and attend your
If I find
matters.
something, Malad, I will
Please
place,
give it to
Malad,
us.
These honorable court's orders, Malad, 1 or 2, whatever I was supposed to place today, along with, Malad, anything there of the Supreme Court.
Done. Yes, arguments concluded. Judgment reserved.
Malad.
Mr. Upadhyay, why do you leave when the matter is going on?
No, sir, just.
He does not appear, it is his problem. You should be in the court. We are facing a blank
Lord, I'm sorry.
respondent side. Does not look good.
I'm sorry.
Item 16.
Hmm.
This matter arises from a dishonor of check case, my lord. So, prisoner was accused and he was convicted. And sentenced to fine only, not imprisonment. So therefore, he preferred an appeal. He preferred an appeal against the judgment and order of conviction.
20% to be deposited.
Yes. This is
Then
the
we
issue.
asked how much you want to deposit.
This is the issue, my lord.
How much can you deposit is what we asked. Did you
So-
not ask? No.
No.
What was the amount? Compensation was of how much?
20 lakhs. 20 lakhs.
6% is or 20% is?
4 lakhs. 4 lakhs. So, I am unable to deposit this.
There is an alternative given.
And also,
In the order, there is an alternative given if you cannot pay.
so that's
Do
why
that.
I'm before this honorable court.
Do that.
This without
Money taken,
without resolving-
concurrent findings.
No,
I cannot
not
pay.
concurrent finding. The appeal is pending.
Ah,
So there is only one finding by the.
okay. So the appeal, you want to have the appeal heard by depositing that money.
Yes.
Appellate court does not say that we'll hear you without depositing the money. What is your ground of appeal?
Because this direction is
Ground of appeal.
ground of appeal.
Huh?
Ground of appeal is because the London trial court held that I could not rebut the presumption under section 39 and 80. Right. So there is materials that came out during cross-examination that probabilize that that raises doubt about the cases and that rebuts the presumption because this case is
How much can you?
my lord,
I cannot give
I
anything. Is
am
not-
challenging this direction on the ground that it is not reasoned. And there are judgments that it is discretionary power under section 148 and it should be exercised.
Where is that order?
The order is at page 122.
122.
122 and the direction is the last paragraph of 122. There is a common order passed for
That money is not going to him, is it?
my lord.
That money is presently not going to him.
My lord, otherwise not. Otherwise, first it has to be deposited. Thereafter, the.
You will have to
Sessions
move
Court
an
can-
application.
Yes, the sessions court can allow it
Yes,
to be deposited in my favor.
Ah, you deposit it in the form of fixed deposit or whatever. You give adequate surety there. Any difficulty? If it is a bail case, adequate surety. If you do not have the money now,
That's why the first submission was that I am not able to deposit at the moment.
what do you do as for a profession?
So, and otherwise on the ground that the direction is not reasoned, that I have some judgments.
Saying that, simply saying
Saying
20.
that it needs to be reasoned. This there should be judicial application of minds and showing reasons why it is required to be directed to pay this amount. May I please do? So there are some other High Court judgments based on Supreme Court judgments. This first is by June, paragraph 5, 6, 7, and 11. 5 quotes the Supreme Court judgment. May I read the
Judgment could be to quick.
Yes, citation.
By
The next is C.R. Balasubramanian, my lord. This is also paragraph 5 and 6. And the next is
Send it back.
No, my lord, I have some reservations. What has happened is, so,
Supreme Court judgments are there also.
my lord, what is the Supreme Court judgment that is holding the field? So it is one case by the name of Surinder Singh Deswal. Then came Jambu Bhandari.
It is there.
It is there. My learned senior counterpart has written upon that. So first, my lord, I will not harper on Surinder Singh Deswal. The law that is on the field right now, my lord will have this copy that I have, if possible. My lord will see page number 2 of the instant judgment. May I read, my lord? My lord, so Surinder Singh Deswal was a division bench judgment of the Supreme Court, which said that in 148, may shall be construed as shall. So there was very little scope of going here and there from imposing the conditions of 148. Thereafter, Jambu Bhandari came, and Jambu Bhandari has reiterated the same proposition of law. But my lord will see paragraph number 6. That is why I won't go on Surinder Singh Deswal. This has beautifully summarized what is the position of law. Paragraph number 6 at page number 2. May I read, my lord? What is held by the court is that a purposive interpretation should be made of section 148 of NI Act. Hence, normally appellate court will be justified in imposing the condition of deposit as provided in section 148. However, in a case where the appellate court is satisfied that the condition of deposit of 20% will be unjust, or imposing such a condition will amount to the deprivation of the right of appeal of the appellant, exception can be made for the reasons specifically recorded. Now, my lord, why my reservation is there? That when a submission is made that a reasoned order has to be passed for 148 to be imposed, that is wrong. 148, when it is been given, no reasoned order has to be passed. But when an exceptional case is made out, in 2 grounds, number 1, whether it will be unjust, number 2, whether it will deny him his right to appeal, then the learned sessions court will pass a reasoned order saying that 148, let it be relaxed with. Now, my lord, in this case, what has happened is, even if he is saying that he cannot pay the amount, my lord will see the order dated 31 of this honorable court. The last order of this honorable court.
So that's the High Court judgments that I have placed before your lordship makes it clear that reason is required. Either it is given to 20% is imposed or 20% is not imposed. In both ways, the reasons should be given. These judgments of the High Courts made it clear. That's why I have placed them before your lordship.
My lord, why I am on the point of High Court, my lord will see the judgment and know. So there are 2 judgments holding the field, Deswal and Bhandari. Now, my lord, different courts across the country have interpreted it in their own way. But this is the way Gauhati High Court has interpreted it. My lord will kindly come to paragraph 2 at page number 2. Secondly, whether an appellate court is an appeal preferred against the judgment and order of conviction and sentence for an offence under 138 of the Act is to assign any reason while directing the appellant to deposit an amount in terms of the provisions of.
Did
Section
you,
148.
your appeal is here?
Yes, my lord. Yes, my senior is annexed it. Is annexed.
You have annexed the appeal.
Yes, ma'am.
Where have you stated that you are not in a position to deposit it?
That is not there.
My lord, the moment that averment is not there,
Heard. Mister,
Follows.
dispose it off. We will give you the liberty to approach the trial court, the appellate court with an application that you cannot deposit it. So there may be some mercy.
Fine.
The trial court would consider it only on merit and
Yes.
proceed.
my lord, if just my simple one-liner objection may be taken. note
Ah,
of.
yes, yes.
My lord, on 30th of January, they come up before this court and say that we want to
Yeah.
settle this matter.
Yes,
We
still
want
we
to
are,
settle the matter. And thereafter, on the 27th of February, they are saying that they don't have the money to pay it out. Now, my lord, when this
Yeah,
was
for
the situation,
settlement.
now, my lord, within 1 month, I must respectfully submit.
We are always open to settle it, amicably.
Yeah, he'll settle it. You don't take the money. He's ready to settle it tomorrow.
2016, this case.
You are causing all the problems by not taking.
I must pray, my lord will protect me. I have fought since 2016. This is the.
Heard Mr. Olaskar counsel paying for the petition also. Heard Mr.
N.
D.K.
Kothari.
N. Kothari. Planet counsel paying for the respondent. The crux of the present criminal petition is the order dated 16/3/2024 passed by the Court of the Learned Additional Session Judge number 5 Kamrup Metro at Gauhati in criminal appeal number 27 of 2024, by which the appellant herein was directed to pay 20% of the total compensation amount as passed in the order and judgment dated 15/2/2024 in CR case number 1302 of 2016 in the proper government head through the learned Chief Judicial Magistrate Kamrup Gauhati, and thereby deposit the receipts. The execution of the judgment of the lower court was kept in abeyance till 25/4/2024. After that, what happened?
So that I filed application saying that we have approved this honorable court. So it was the
My lord,
proceeding itself. was
Without
kept
a
in
stay order,
abeyance.
it was kept in abeyance.
Yes, there was no stay order, but we have requested the court.
Mr. Kothari,
My lord.
there are embarrassing situations in the court when an awkward question is asked which is difficult to answer by any of the counsels.
Right.
Do not add fuel to the fire. Keep quiet.
My
You
My lord.
understand what we are indicating here?
Understood, my lord. Understood.
There is another saying called flogging a dead horse. No need to flog it.
My lord.
It is dead anyways.
I've understood.
When we ask something to him, he will answer it. Yes, what were we saying? Yes. The appeal arose out of a judgment and order dated 15/2/2024 passed by the learned Chief Judicial Magistrate Kamrup Metro Gauhati in CR case number 1302 of 2016. It is obvious, therefore, that the trial had proceeded for nearly a period of 8 years from the date it was instituted. And even though no interim orders had been passed by this court in this criminal petition, due to the pendency of this petition, the trial court has not proceeded with the criminal appeal, respecting the pendency of the litigation before this court. Mr. O. Losman and counsel for the petitioner has submitted that the impugned order dated 16th, then another thing, Mr. Loskar, if we interfere with the 16-2024, it has to go as a whole. So the stay goes. The learned counsel for the petitioner has submitted that the impugned order dated 16-2024 is liable to be interfered by this court since the appellant accused was directed to pay 20% of the total compensation amount as passed in the judgment and order and judgment dated 15-2024, and no reasons have been given as to why the learned appellate court had come to a conclusion that it was necessary for the appellant to have deposited 20% of the compensation amount prior to the appeal being taken up for consideration. Full stop. The learned counsel for the petitioner has placed reliance on this. I'm marking it with the red. I'm writing down P. P. Then P. To emphasize that the courts time and again emphasized that the orders requiring the payment of 20% of the compensation should be accompanied by reasons as to why the appellate court deems it fit to have such conditions to be imposed upon the appellate. Mr. Kothari, learned counsel appearing for the respondent, has, on the other hand, drawn attention of this court to the case of Jambu Bhandari versus MP State Industrial Development Corporation Limited and others, reported in 2023 10 SCC 446, wherein at paragraph 8. Did you say paragraph 8? No, paragraph 6. My lord. The apex court has held as under. Mr. It is the submission of the learned counsel for the respondent that reasons are to be given by the appellate court when a relaxation is given on the imposition of the condition of a pre-deposit of 20% of the compensation amount is granted by the appellate court, and no reasons are required to be given when the learned appellate court proceeds to impose the 20% to impose the pre-deposit of 20% as a precondition to proceed further in the appeal. Full stop. The learned counsel for the respondent has also placed reliance on criminal petition number 87 of 2019, which was disposed of on 13/5/2022, wherein this court had framed the following questions. This one at paragraph 2, you'll take down paragraph 2, then you take down paragraph 4, and then you take down paragraph 12. No, sorry, paragraph 11 and paragraph 12. Okay. In such circumstances, this court has on earlier occasions rejected the plea that reasons are required to be given for imposing the precondition of depositing 20% of the compensation amount upon the appellants for having the appeal proceeded with. Next paragraph. In the present case, we notice that although this court had not stayed the proceedings in the appeal due to the pendency of the criminal petition, the appeal has not proceeded in. Full stop. This has not harmed the proceedings in any manner, since till the time the pre-deposit is made by the appellant hearing, by the petitioner hearing, who is the appellant in the who's the appellant in, what is that number? Criminal appeal number 27 of 2024, full stop, comma. The appeal would not in any way proceed. However, we are disturbed that by keeping the appeal pending, while keeping the appeal pending, the interim relief granted by the appellate court in suspending the execution of the judgment of the lower court in abeyance till the next date fixed has harmed an early disposal of the matter. Full stop. The provisions of the Negotiable Instruments Act as observed by the Supreme Court or by the Apex Court is that the Negotiable Instrument Act has been amended from time to time so as to provide inter alia speedy disposal of cases relating to the offense of dishonor of checks, so as to see that due to delay tactics by the unscrupulous drawers of dishonored checks, due to easy filing of the appeals and obtaining a stay in the proceedings, an injustice was caused to the payee of a dishonored check who has spent considerable time and resources in the court proceedings to realize the value of the check, and having observed that such delay has compromised the sanctity of check transactions, Parliament has thought it fit to amend Section 148 of the NI Act. Therefore, such a purposive interpretation would be in furtherance of the objects and reasons of the amendment in Section 148 of the NI Act and also Section 138 of the NI Act. Then you write in bracket, as observed in Surinder Singh Deswal, alias Colonel S.S. Deswal, and others, reported in so and so. Okay. In the present case, it is observed that the pendency of this petition has in fact harmed the disposal of the appeal and the probability of the holder of a dishonored check from getting his due payment. Full stop. True, it may be that in the appeal, the appellant may succeed, but keeping a proceeding pending before the learned appellate court, when a stay has been obtained, comma, this court finds it a fit case to, should we? Finds it a fit case not to interfere in the condition imposed by the learned appellate court while requiring the deposit of the 20% of the what amount? Compensation amount, full stop. This court has, however, taken into consideration the submission of the learned counsel for the petitioner, that the petitioner may be is in genuine difficulty in accumulating the amount directed by the appellate court to be deposited, full stop. If that be so, the petitioner would be at liberty to prefer an appropriate application before the learned appellate court, praying for condonation of the aforesaid condition by bringing in such cogent materials as may be necessary for the learned appellate court to come to a conclusion, full stop. The aforesaid application, if any, be filed within the 18th of March 2026.
May be given.
Sorry?
1 month may be given. Recently, the petitioner's mother died. And
Okay.
He's from Silchar.
Uh,
1 month.
No,
time
no
may be
objection, my lord. No.
On or before the 2nd of April?
My lord.
The entire March you have got then?
Yes,
huh?
my lord.
2nd of April 2026. And such petition, if filed within such date, shall be taken up by the learned appellate court and disposed of summarily, either accepting a diminished deposit or by rejecting the petitioner and directing the appellant to deposit the original requisite, full stop. It is made clear that in the failure of the petitioner to approach the learned appellate court within 2/4/2026 or in the failure and further in the failure of the petitioner to comply with the orders passed by the learned appellate court in any representation made by him for condoning the deposit, comma, the learned appellate court shall take into consideration the attempt of the petitioner to delay the proceedings and would also consider vacating the stay of execution of the judgment and order passed by the learned trial court. Stop. Criminal petition dismissed.
In case petitioner doesn't appear or comply with the order, right?
We have said that in case you do not appear on or before 2nd of April, and once you file the application and the application is disposed of, you do not comply with the order.
There is no question of non-compliance. So far, my conduct in the trial, my lord, there is no problem with that.
Which trial?
So the petitioner as an accused, there was the petitioner didn't.
I have said that if you do not appear before 2nd of April, and in the matter of your in the event of your appearing, and the court passing an order on your application, you do not comply, then the stay will be vacated. If they ask you to pay 5%, you pay your 5% and you continue. If they condone it, you condone it and continue. If they say 20%, either you pay the 20% or the
My lord,
stay gets vacated.
Yes.
Pay the money.
my lord,
Lost a case, pay the
one
money.
thing, the only embargo is that it cannot go below 20%. So the wording of 148 is as such that it shall be a minimum of 20.
Go and you contest it there, sir. He can condone it to the 0 also.
If it is called
Then-
0, then my lord,
If it is 0 or 20,
0.
so he will ask for 0, you ask for 20. Argue it there, finish the matter there quickly. Or you want us to continue with the litigation?
my lord.
We can
Grateful,
end out
I'm
of
very grateful.
litigation.
I'm very grateful, my lord.
Obliged.
Yes.
Lordship, impugn judgment is at page 41.
Page 41.
Page 41.
Hmm.
Relevant portion is at page 48. This is the appeal referred by the accused petitioner before the session judge Sira, challenging the order passed by the Honorable Chief Judicial Magistrate Sira. Lordship may kindly have a look at page 13. That is the judgment.
She was standing by the road, beside the road, in the lane, when this dumper came. Was it filled or unfilled? It had some materials on the, it was carrying some material or nothing?
Nothing.
Nothing more dangerous than a empty dumper on a highway. Nothing more dangerous in this world. It is like giving a shotgun to a monkey.
Lordship.
You don't know when it will fire.
Lordship, it
Have you
is-
seen their driving?
Lordship.
Any care and due diligence exercised by one of them? Hmm. 3-4 times perhaps we were lucky.
My humble submission is only that it is purely an accident.
Huh? It's an accident, yes. She was standing by the road,
By the road.
not inside a shop.
And
What,
there
this
was
road
no
was under the
eyewitness-
making?
And there was no eyewitness for whose fault the accident took
Oh,
place.
no. This man has said,
He has heard the voice of accident only, heard the sound of accident only.
Huh.
Thereafter, he rushed to the place of occurrence.
who had seen the vehicle knocking down the deceased. Page 44, am I reading wrong? And then this man gets down from the vehicle and runs.
Let's put it forth. EW2. Lordship may kindly have a
Hmm?
look at this.
Have you given it here or?
Page 16, Lordship. This is the deposition of TW2, on the basis of whose statement Lordship judgment was passed. TW2. He was having a cup of tea and he had heard a sound and he turned. He had seen a dumper committing an accident, and the said dumper was being driven by the accused, and he had seen him running away. He was not the eyewitness.
Hmm. Were you driving it? Yeah.
S16 TW2.
Do you admit that the person, the accused was driving it or no? He was not driving it.
It is the driving.
Accused was driving it, but it was an act of mere accident.
TW2 was standing 25
No, no, no.
meters.
According to you, how did the accident happen? You must have some story as to how the woman came in under your tires. It is a big truck.
Actually, Lordship, at that time there was a dust. So accused was
You must tell us why we should take it now. There are instances where we have seen that the person who was trying to cross the road in a busy area, national highway, there was some kind of a market, daily market, Sunday market, something. Highway, it was 70 citing 70 km/h is the speed. So this man was going at 70 km. One man tries to cross the road. He cannot apply the brake. Hit. That is an accident. This man does not know that it is a highway. I should not cross the road. That man forgets that it is a market day. I should not drive at 70. They get hit.
It is true.
Here is a case where he is going by the side lane. Dusk.
Dust.
Dusk or dust?
Dust, Lordship.
K or T?
T, Lordship.
T.
T, Lordship.
Dust, he did not see the lady standing near the road. 6 months.
6 months and 2 years, Lordship.
2 years are there.
2 years also, Lordship. For 304A.
Hmm?
For 304A.
When was the accident?
Accident took place on 25th February, Lordship.
25th February what?
2024, Lordship.
24. What is the age of the accused? Hmm? Anywhere we can find the age of the accused.
Yes, Lordship. 35 years, Lordship.
35 years professional. He has a license.
Lordship.
What do you say, Mr. Goswami?
Only thing is that PW2 has stated that he was not an eyewitness on
He
there.
was not an eyewitness.
No, but the cross says that when I had turned my head, I heard a sound, I turned my head, I saw this happen. But the dust part, I don't know whether it is there on the evidence. Anyway, there in the evidence about a dust part.
CR receipt, we have not gone through it, Lordship.
Oh, then you can go through it. We'll have it on the 6th. We'll have it on the 6th.
Humble prayer is that some mercy will be.
Huh?
Some mercy will be.
Mercy is what
Because it is purely an accident. Lordship. That is.
we try. That is why when was the incident? If it was too old an incident, we would have gone for the fine part.
I agree.
2 years ago only. What about that MSCT case? It is running, no?
I have no knowledge.
Find out, tell us, this is what is coming up.
Lordship.
But if it is 304,
We have to go to TCR and non-safe Lordship will consider a pair of. This
it is here
Yes, yeah.
on the 5th or 6th,
Sixth.
on the 6th of March for the APP to go through the TCR full stuff. The case arises out of a road traffic accident where the appellant has been convicted for a period of 2 years.
He's on previous bail. He's on previous bail.
6th of June.
Obliged.
See if we can go for the fine part and then finish it off. 35 years old, matlab, he must be a professional feeding his family. Intention to who would try to kill him with all the dust. No one will try to kill him.
Obliged.
Friday. Yes, madam.
May it please, Lordship.
119 days.
Lordship.
You are appearing for?
Respondent.
You have any objection?
Lordship.
You have any objection?
Lordship, though delay was not properly explained, but considered a medical ground, I have no objection.
We'll condone the delay, go for the revision.
119 days.
None appears for the petitioner on call. Miss
D. Pathak.
appears for the respondent number 2. Mr. Goswami for the Mr. Goswami as the APP. The learned counsel for the respondent number 2 has submitted that although the grounds given in the interlocutory application are not confidence inspiring. However, since the medical emergency has been taken as a ground comma, this court to take its own decision. Now may like to consider, may take a decision as to whether the delay deserves to be condoned instead. In the facts and circumstances, this court does not find any reason not to condone the delay or that the petitioner had been or that the petitioner had caused any delay in preparing the application. Therefore, the same is allowed. Accordingly, the delay condoned is, the delay of 119 days is condoned. List of interlocutory application is closed. Registry to list the criminal
Revision petition.
revision petition
High level.
on its own turn.
As per the last direction given by the Honorable Court, the petitioner appeared before the learned court below and filed a necessary application by an objection against the final report. So it is fixed on 2nd of March next month.
On the
2nd of March.
so we'll have it sometime on the 16th,
Yes.
16th of March. Mr. Biswas, learned counsel appearing for the petitioner has submitted that the matter has, that an application has been filed before the learned trial court, and the matter is fixed on the 2nd of March. Accordingly, list this matter again on the 16th of March for an updated status to be provided by Mr. Biswas.
Much older.
Please, Your Lordship.
Yes, ma'am.
Lordship, through this petition, I'm challenging an order passed by additional session judge, thereby rejecting the custody of my mobile and several other important documents, such as Aadhaar card, ATM card, PAN card, etc. On the several occasions, they took time for submitting the report from the investigating officer. It's 203 days, Lordship, counting.
Report is, we have received the report, Lordship. May I read, Lordship, the report? It is pertinent to mention here that the seized mobile phones have already been sent to the Forensic Science Laboratory, Kahilipara, Guwahati, Assam, for scientific examination by the FSL memo number so and so, Lordship, for obtaining expert opinion. And that report is still awaited from FSL Kahilipara. That's why, in order to obtain the pending report in respect to the aforesaid seized exhibit, this office has already communicated with the Director of Forensic Science Laboratory, Kahilipara, Assam, by number so and so, Lordship, dated 4 and 26 by deputing a messenger. However, the said report has not been yet received, as it is still not ready. Hence, pray the Honorable Court may kindly not to release the aforementioned seized mobile phones in Zimma to the petitioner at this investigation, as the investigation process technical of the case will be hampered. That is the report from the IO.
We'll have to wait till it comes back from the FSL to see whether we can. Yes, madam, they are.
Lordship, there was a similar case, and they have already allowed 3 mobile phones in this.
So as
The honor, the court's order, I have not.
it will be
It's a hard
difficult
copy
for us
with
to
me.
go through your mobile, madam. You'll have to give us the case number, the printout,
Yes,
something.
same case and
Hey,
same CD,
who gave the custody? Who gave the Zimma? The High Court,
this
the trial
honorable
court?
court itself.
Huh?
This honorable court itself.
Show us the order. Kopsun ki order number, case number ki man kopsun.
Lordship, criminal petition 1158/25. 1158/25.
Just a minute.
They were the main accused, Lordship. They have already got the Zimma of their mobiles. But this particular person is yet to receive.
In that case, the FSL had been received. He was in the order.
Lordship.
In that case, the
Lordship, in fact, this person, the particular present petitioner, he was not at all involved in the case and his name was not in the FIR. He was just randomly arrested.
Huh?
And he have got the bail.
They are not in the FIR. You are arresting him, taking away his mobile.
This particular person is not.
Investigation authority.
We'll give you this FSL report and all, Karwai, because in the similar case, you have got the FSL report.
But we have not received the FSL yet.
When did you take it? When was it sent?
It was sent in, Lordship. We have received 26 to 26.
26 to?
Not 26. Sir.
Day before, yesterday you sent it.
We have, you have received it.
You have received what?
FSL, Lordship, lots of time. FSL,
When did you send it for FSL? We'll ask the FSL persons to come here.
First 4 to 26. And as per the FSL memo number forensic lab, officer already communicated with the director communicated on.
When, date?
4/2/26. 4/2/26.
On 4/2/26, he communicated with the FSL director.
And send of FSL, it will, when it was sent for FSL, that will reflect from the.
Kindly find out. Where are they retaining a mobile? What mobile it is?
Lordship,
Some very good mobile.
Realme, I think.
we are not very much concerned about the mobile, but I have the ATM card, COVID vaccine.
Oh, and what about the ATM card? Why are you retaining it?
Regarding the here ATM.
Have
card-
you seized the bank account?
That-
Has the bank account been frozen? Then retaining the ATM card, what kind of a? She cannot apply for a new one. She cannot. Huh? Then you are keeping back the driving license, PAN card, voter ID. These are all duplicates are available in the market. She can apply and get a new one anytime, any day.
But that report is only regarding for the mobile phone.
Why the rest of it is not being released to her?
That part, Lordship, I have to take instruction from the concerned authority.
5th or 6th?
6th.
6th of March. The learned APP shall list again on the 6th of March. The learned council for the learned APP shall have specific instructions as to why the documents of the petitioners have been kept under confiscation, which include a driving license, the PAN card, the voter ID, the ATM card, 2 ATM cards, the COVID-19 vaccine card, Aadhaar card, etc. Full stop. The learned APP shall also request the shall have the report from the IO as to whether there is any deliberate delay on the part of the forensic department in giving the FSL report in the matter. So tell us, let him ask. Because the report deliberately delayed. Let the FSL say no. 5th of March, madam.
Obliged.
6th.
Okay, obliged.
Yeah, get us, sir.
Finding item 24.
Acha, Mr. Goswami, we would like to observe that you may release it in the meantime if you think it fit. Those documents, if you want to release, you can release it to them. Huh? You tell them if they want to release, let them release. At least the document part.
Yes.
Yes. Yes, sir.
Lordship, that DRS can copy, I have gone through it, Lordship, but I have failed to find out the 47 and 48 notices. But the order of arrest memo and intimation to arrest and other parts in the index.
47, 48 is not there.
47, 48 I have not found. Or the intimation to the family members or communication was made by the index part, Lordship. I have seen it. And the order of the trial court, that is reflected, yes, intimation of arrest. But in the way of 47 and 48 notice on the.
No, at least intimation of arrest is where? There must be a document that this is the intimation of arrest. Yes, give us that other part.
That is not clear out from the scan copy, Lordship. That 3 sets are there, but in arrest memo is there, but intimation of arrest is what type of intimation they have made, but it is not clearly reflected in the trial court record. So let them appear by DRI council, Lordship. Let them appear here, DRI council, they will make their submissions on that regard also.
You were driving a truck and heroin is found in death.
Lordship, according to petitioner number 1 is the driver.
Petition number 1 is the driver.
Driver.
And petition number 2,
Who is it?
huh? Helper. Matter was called twice. Scan copy of the TCR is
TCR.
available.
Charge is already framed.
None has appeared for the DRI on both the occasions.
How many khapor is in there?
The learned counsel for the petitioner has submitted that in the absence of the notices under section 47 and 48 of the BNSS or any similar notice being supplied either to the petitioners or to their friends, family and relative, the arrest and further detention has been rendered illegal. The matter relates to confiscation, to recovery of contraband items. In the interest of justice, release this matter again on the 5th of March, 2026. Allowing an opportunity to the DRI to appear in the matter. It is made clear that if none appears, this court would proceed on the materials available in the trial court records to determine whether the adequate provisions for guarding the constitutional rights of the petitioner under Article 22(1) has been violated and whether the arrest stands vitiated.
All right.
Yes. Cow. Huh? Who is the driver? Have they appeared? Anything? Have they appeared?
Yes, they not received yet report.
Case diaries. 21-1-2026. CD has been received.
Telephone instruction.
Whether they have appeared or not.
32 no. Mickey Veta 154.25.
They were required to have appeared on or before oh. They will make themselves available for interrogation within 7 days.
Yeah.
7 days is from 16/12. So they should have been available before the investigating authority within 7 days. 16/12, 20/12, 21, 22/12 maximum. The CD is updated till when? But it is said that CD is
Today or last day.
received today. 21-1-2026 order says CD has been received.
Let the CD has been taken back by the.
Shall be retained. Huh? None appears for the petitioner called. None had appeared on 21-1-2026. List the matter again on 2-3-2026 for the IO to intimate whether the petitioners have cooperated in the investigation as required by the order dated 16/12/2025.
For item 47.
Yes, madam.
Both parties agreed that matter may fix on 11th of March.
Parties are aggrieved. Is the agreed? Is the court agreed? What is this matter about? So, what is your ground of challenge?
Lordship, punishment is 5 years, my lord, and 1 year, 8 months has already gone by now.
Hmm?
1 year, 8 months behind bar.
He's already behind bar. You are appearing for the informant.
Yes, sir. Respondent number 2.
You will object to the appeal.
Yes, your lordship.
Okay. At the request of the learned counsel appearing for the contesting parties, list this matter again on 11th.
11th of March.
11th is a motion day.
Then 2.
12 কিমান আছে? 12 কিমান আছে? Huh? 10th. On 10th, can you be here?
Lordship.
Difficulty, 11th. 11th of March.
Obliged. Thank you.